Okay, good morning. It is Thursday, June 13th, 2024, and welcome to the regular meeting of the California Fair Political Practices Commission. Ms. Linker, will you please take roll?
Commissioner Baker,
Here.
Commissioner Ortiz,
Here. Sorry.
Commissioner Wilson,
Here.
Chair Silver.
Here. Excellent. Why don't we start with item number one, and that's going to be public comment for items that are not on today's agenda. Do we have any public comment for items that are not on today's agenda? Hearing and seeing none, why don't we move on to item number two, and that's going to be approval of the May 2024 minutes. Commissioners,
Motion to approve the minutes.
appreciate it. Any, before we move to approve, any suggested edits? Commissioner Baker?
Oh, sorry.
There's one small one. I apologize for not noting it with staff sooner. On the bottom of page 5, it's probably a typo, understandable. It says Mr. Lindsay pulled a streamlined manner, and I think it's matter. So just if we're going to approve minutes, I thought I would just double check. That's the only suggestion.
Thank you for pointing that out. Always appreciate your attention to detail, Commissioner Baker. General Counsel Bainbridge, are we able to make a motion to approve the minutes with that one edit? Excellent. Could I get a motion?
Motion to approve the minutes with the edit.
Excellent.
Second.
Ms. Linker?
Commissioner Baker,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
The motion passes.
Excellent. Well, we're going to move on to our consent calendar. We're going to start, I believe, Mr. Bainbridge, can you confirm whether item 3 was removed?
As far as I know, it's still on the agenda. It can be removed if that's what we want to do,
Okay,
but it
it's,
still appears on the
And to
agenda.
be specific, I'm talking about the default proceeding.
Right.
Correct. Okay. It appears we may have public comment on item number 3, so I think we're going to remove that just so that we can address it to the extent there is public comment. And then following that, we'll also be addressing the updated campaign disclosure manuals. So why don't we start by addressing item number 3, which is in the matter of Ramos for City Council 2018, committee to elect Daniel Ramos, Adelanto City Council 2020, Daniel Ramos, Ricardo Ramos, Arlie Arseneda, and that's case number 19464. And we have our Chief Enforcement here, James Lindsay, to present. Good morning, James.
Good morning, Mr. Chair. Good morning, Commissioners. That is correct. Our intention, as you remember from the last commission meeting, we had this matter on for pre-notice for the default. I had indicated to the commission that we, in response to the pre-notice, we had received some communication from Mr. Daniel Ramos, and that we would be looking again at where we were going to find out what filings occurred over this past month. Mr. Ramos has filed a considerable amount of material, as I understand it, especially in the last few days. And it was our intention to pull the matter so that we can see where we are in terms of compliance and also engage Mr. Ramos further on potential resolution that isn't a default. That doesn't mean that we won't come back in August and pursue the default and that penalty or something similar. But we do want to make sure that we give Mr. Ramos every opportunity to have an opportunity with the Commission's indulgence.
So I appreciate that update. Do we have any public comments on that item?
Mr. Chair, I just want to note on the Zoom, your microphone is either not on or there's something audio happening.
Thank you. It looks like we're having some issues with the call as well. Go ahead. Public comment.
Yeah, this is resident Angela Miss. I'm just calling in behalf of Daniel. As you guys are extending some time for him, he's been doing great work in the city. Hopefully we can get this behind him. He's a pillar of our community and he's doing great work for the city. So we just hope this gets behind us and we can move forward. That's my public comment. Thank you, guys.
Excellent, thank you. Any additional public comment? Yes, we have additional public comment. Go ahead.
Hello.
Good morning. Go ahead.
Good morning. My name is Diana Esmeralda, and I am a resident of the city of Adelanto. I have been greatly affected by Mr. Ramos and his actions. But there are so many financial documents and campaign funds that were expended that are not in his paperwork. They're not in the paperwork for Mr. Angelo Meza, who just spoke, and they're not in the paperwork for the mayor, who actually endorsed and gave funds to Mr. Ramos and Mr. Arley for their campaign, for this campaign. Mr. Arley is also on a committee for the city of Hesperia, which is a concern. And Mr. Arley went with Daniel Ramos to several different functions for his position as city councilor. But those funds that were directed to Mr. Arley for California League of Cities and other things like that were never put forth in the receipts for Mr. Ramos. So also, Mr. Ramos has started a food truck company, Market 760, and has begun to duplicate the county processes for licensing, requiring companies to double license without any of the infrastructure that the county provides for us. It's just a big, we have questions. Where is the money going for Mr. Ramos, for the city council? Councilors are talking about personal church matters, and
I apologize for
making-
interrupting you, and I really appreciate you taking the time to comment today. I just want to make sure that the information you're providing us is within the item that's before us. I don't want our body to be prejudiced as a quasi-judicial body. So what I just want to make sure is that all this information that you're providing us, that have you provided that to our enforcement division as well?
yes, I have for several years now. And
Excellent.
the harassment has not stopped from Mr. Ramos. Code enforcement came by my house yesterday. He demeans and expresses to the public his disdain for us when we go to city council meetings. We have been called outright liars. And I have personally been harassed by Mr. Ramos during campaign season. He has been disrespectful and arrogant to the point of not putting in his campaign paperwork. This is unprecedented, and he needs to be reprimanded to the fullest extent of the law. I
Well,
appreciate you.
Again, we appreciate you taking the time to present your public comment. Certainly all those facts are items that the enforcement division is going to consider in this matter. So thank you again for that. And if anything additional comes to light, again, make sure you forward that along to the enforcement division. Do we have any additional public comment? Okay. Do we need to take any action in this? I believe the answer is no. So hearing and seeing no additional public comment, we're going to move on to item number 4.
So
Thank you, Mr.
just
Lindsay.
to clarify the record, that item has been removed from the agenda today, correct?
Correct.
Okay.
Excellent. Thank you, Mr. Lindsay. Okay, let's move on to item number 4, and that's updated campaign disclosure manuals 3 through 7. Appreciate Ms. Chloe Hackert, our Education and External Affairs Unit Manager, coming up to walk us through these. I also appreciate that you took a look at the comments that were provided by California Political Attorneys Association and we made the appropriate edits, responses to those. And thank you to the association for providing those. We really appreciate your expertise in this area. So go ahead, Ms. Hackard. Good morning.
Good morning, Chair and Commissioners. Chloe Hackert, Manager of Education and External Affairs Unit. And before you today are updates to Campaign Disclosure Manuals 3 through 7. That covers ballot measure committees, general purpose committees, major donor committees, independent expenditure committees, and slate mailer organizations. So we pre-noticed these for public comment in April in advance of the June Commission meeting. We received comment from CPAA. And then along with posting them for the June agenda, we received comment as well from CPAA regarding some changes with cryptocurrency and advertisements, and we've made those corrective changes. And they're before you on the website, so you can see them. We post them, and so we are really appreciative of CPAA taking the time to review them and give substantive feedback. We are really open to collaboration and are happy to have the feedback. So we made those changes. Some of the other requested changes in the comment letter are being vetted and reviewed. Some of them require a bit more research before we're going to put them into the manual. And our plan going forward is to do these on a much regular basis and trying to do these yearly going forward. So we've been in communication with CPA, explaining the timeline and how going forward we'll be reviewing those requested edits to be put in the manual and looking forward to those possibly for the next year's round of edits regarding regulatory and legislative changes from this year. So the plan going forward is to have these much more updated much more regularly every year, and hopefully there'll be less updates and less to review and less to issue spot.
Excellent. Before I open it up to fellow commissioners, I just want to say thank you to you and your division, the legal division, for getting this done so quickly. I think we just had the cryptocurrency regulation before us last month, and you already have updates to the manuals, and that sort of quick turnaround is crucial in an election year.
Yeah, so
thank you
big
again.
shout out to our desktop publisher, Mason Lord. We work with Adobe InDesign. It is a program that I am not skilled in, so we're very grateful for her to be able to make these updates so quickly and to get them before us, to get out to the public before the November election.
Excellent. Thanks again. Any comment from commissioners? Commissioner Wilson?
I'll defer to Commissioner Baker, and then I'll have it.
Commissioner Baker?
Thank you, Commissioner Wilson. And I just, as a clarification, that matters that CPAA commented on that are not going to be reflected in the existing changes today are because you have to do further research.
Yes, there's a couple of comments where there's requested changes, for instance, like referring to an advice letter. And and changes like that, we want to be able to see that advice letter that applies today in today's law, and that it would be applicable in all circumstances to be in a manual that someone can refer to. Because these manuals are used by everyone. We use them as staff. The regulated community uses them. The public uses them. So it's kind of a great compromise of all the information. And we want to make sure it's applicable to everyone if we put it in the manual and not a certain set of facts. And other ones may be opening discussions with Secretary of State or forum updates. And so that's why we're requiring a bit more vetting to be able to see if it is applicable for the manual or if that's an open discussion to move into form edits or changes. So that's why those may be reflected in later updates or maybe in other educational materials, depending on those discussions.
Thank you. It's not that we don't want to do those changes. They just require further work, and it's important to have manuals now for this election as much as possible. Thank you. I appreciate the clarification.
Commissioner Wilson?
Yes, thank you. I just want to, commend you and, your team for the detailed information that's available on the website. Initially, I thought, well, maybe I'd print this out, and I realized, oh, wait a minute, that's 200 pages. But but it is very helpful, very informative, and for the benefit of the public, if you go to the FPPC website, all that information is readily available in addition to what's posted for today's meeting. So thank you very much.
We appreciate it. Thank you.
Commissioner Ortiz?
Yeah, thank you. I'm curious, how often do you do the update? Once a year or what?
We're trying to go forward doing them once a year. That's been the practice, but we've had some changeover in staff and we've had quite a bit of changes in the law since the last update we did. So these are a bit delayed because we had everything ready for CARS when CARS was ready to be updated a couple of years ago. And so the manuals are living documents. So we had to take all the CARS information out.
And sorry to interrupt you, Ms. Hackert. So CARS, do you mind providing us some context as to what that is for the public?
That's the Cal Access Replacement System, the online system for Secretary of State, which will radically change how forms are submitted and how things are done. And so, again, a thank you to our team and the prior manager who made all those updates, but we had to kind of walk back a lot of the information in there, save them. Hopefully we can use it when CARD does go live. But that is the reason for some of the delay with these manuals is we had to take all that out, and we had quite a bit of changes, as you can see in the memo, from cryptocurrency, advertisement rules, excessive contributions. So we put all that information in to get ready for the November election.
Great. Do we have any public comment on this item? Hearing and seeing none. Do we have a motion to approve the manuals?
I'm always making down motions.
You're an excellent motion maker. Okay, as are you, Commissioner Wilson.
I'll be a secondary motion maker. I move the adoption of this item.
Excellent. I second. Ms. Linker?
Commissioner Baker,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
The motion passes.
Perfect. Okay. So now, why don't we move on to our next item? And that's going to be number 5. That's going to be a pre-notice discussion of proposed amendments to regulations 18991, 18993, and 18994, audits and investigations. And I believe General Counsel Bainbridge will be presenting to us on this pre-notice discussion.
Yes, good morning. I'm filling in for Mr. Woodside. He's out today. This reg proposal is really a cleanup measure to a couple of our auditing regs. We did a larger overhaul of the auditing regs a couple years ago. A couple things got missed. The auditors have identified them. Our auditors are dot the I and cross the T type people. So they've identified a couple things that we could clean up. They're consistent with the way the audit division is operating already. So they really are very minor cleanup provisions. The first one involves Regulation 18991. Previously in our regulations in a different section, we had a provision that stated that jurisdictions that are subject to audits either by their local ethics agencies or through a contract with the FPPC, those jurisdictions would be excluded from the draw that the FPPC does to determine which jurisdictions would be subject to audit by the Franchise Tax Board. This was because it didn't make sense for anybody involved to do 2 audits of the same committee. So a common sense measure. It was in our regulation. That regulation ended up being codified, but this provision wasn't included in that, and it was an oversight that no one caught. So the audit division has suggested that since the regulation that had this in it was codified and then was rescinded, that we add this provision back into another section. So it's not anything new. It's how the audit division has been operating. It's just putting it back into the law. So that's the first change we're making. The second change involves 18993 and 18994. These are amendments just to make it explicitly clear that when the FPPC is conducting audits, mandatory audits, that they follow all the same rules as what the Franchise Tax Board does. As you probably know, the FPPC does the mandatory audits for the Controller's Office, for the Board of Equalization, and for the Franchise Tax Board. And they follow the same rules and requirements as what the Franchise Tax Board follows when doing all of the other audits. There were a couple places in the regulations where it wasn't explicitly stated that one of them was a term that was defined that it applied to FTB audits. It didn't say it applied to FPPC audits. We always have applied it, but we have clarified that per the request of the auditors in the regulation. And then the second one is a statement that FTB uses generally accepted auditing standards, as do our auditors. Wasn't in the regulation, so we're adding it to the regulation. So that's all these changes do. I think this is Ms. West here suggested that maybe this would be the first time we put a pre-notice reg on consent, but that doesn't make any sense either. So if there's any questions,
Well, then we
happy
would
to
have
take
missed
them.
your exciting presentation, Mr.
That's right.
Bainbridge.
I kept it
Sure.
short.
Commissioner Ortiz?
Thank you. Throughout the memo, the agenda, you talk about mandatory audits, but on page 2, first time to conduct discretionary audits. What are they and how are they decided that it's a discretionary audit?
Under the statutes, the FTB and the FPPC have mandatory audits they're required to do by law, and then there's also a provision that allows them to do discretionary audits. So basically, that means any instance where either entity feels that an audit would be justified, they can perform an audit on a committee.
So there are no guidelines as to when a discretionary audit comes up. So it's up to a staff person to decide, there is something weird in here, we should look into it.
Yeah, it's up to the agency to determine if an audit's justified.
Thank you.
Any other comments from commissioners? Doesn't look like we have any. Do we have public comments on this item? Hearing and seeing none, this is pre-notice. We're going to move on to item number 6. And that is going to be my apologies for that microphone. There we go. I saw my thumbs up in the corner of my eye from Commissioner Baker. So why don't we do that one more time? How about adoption of proposed repeal and adoption of Regulation 18392.3, honorarium ban exception, definition of predominant activity. And today, presenting on this, we have Ms. Karen Harrison, Senior Commission Counsel. Good morning, Ms. Harrison.
Good morning. All right, and we have 2 PowerPoint presentations this morning, and I apologize at the last minute. IT had a little shuffle. They should be one presentation, but I didn't know how to do that. I didn't know how to make them into one. So IT, if we could go ahead and pull up the first slide on the blue presentation. Thank you. All right, good morning. I'm Karen Harrison, Senior Commission Counsel with the Legal Division. I am here to present proposed repeal and adoption of Regulation 18932.3. This is the regulation that defines predominant activity for purposes of the earned income exception to the honorarium ban. I know that's a lot to take in, so we're going to slow down and break it down. And the first thing we're going to do is talk about the honorarium ban, and that's this first slide that's up. The honorarium ban is an extensive ban that has been in place since the 1990s. And first and foremost, we need to understand that it affects different people in different ways. So if you're an elected officer of a state or local government agency, the statute states that you shall not accept any honorarium. And we'll talk about what honorarium means under the statute. But it's important to understand that an elected officer of a state or local government agency has a total honorarium ban. That means from any source. A candidate for elective state or local office also has that same broad ban on honorarium. But then if you look at Subdivision C, 89502C, which is towards the bottom of that slide, a member of a state board or commission, or a member of a state or local government agency that is a designated employee, they have a limitation on the honorarium ban. And that is a limitation if the source is a source they would be required to report on their Form 700 Statement of Economic Interests. So that's a really important distinction. And there was some question about this at the June 2023 meeting, and it was clarified at that time, but it's come back up in public comment. So I want to be sure that everyone understands what the statute is requiring, that it treats elected officers, state and local, full ban, and it treats designated employees and members of commissions and boards. That is a partial ban, has to do with any source that they would have to report on their statement of economic interests. Okay, let's go to the next slide. Oh, I have a clicker. Thank you. All right, so what is an honorarium? Honorarium has a lay meaning. That means just out in the general public, it has a certain definition, but this is defined by statute. So we're looking at the statutory definition. So honorarium means, except as provided in subdivision B, that means there's an exception that we have to pay attention to. Otherwise, it's any payment made in consideration for any speech given, article published, or attendance at any public or private conference or like gathering. That is the definition of honorarium, and that is in 89501A. Let's talk about the exception now. So we'll go to the next slide. Not sure if Elwin, are you moving to the next? There we go. Okay. So the term honorarium does not include a particular type of payment, and that is a payment that can be characterized as earned income. And the legislature told us what they mean by earned income. It's right there in the statute. Earned income for personal services which are customarily provided in connection with the practice of a bona fide business, trade, or profession. And then there's a list of examples, such as teaching, building, contracting, practicing law, unless, and that unless is what we're talking about here today, unless the sole or predominant activity of the business, trade, or profession is making speeches. And then the commission was given the authority to adopt regulations to implement this specific subdivision. So this subdivision 89501B1, we are charged with the duty of implementing regulations. And it's one of those regulations that we're talking about today. It's the regulation that defines predominant activity. But before we go on, I want us to take a good look at that earned income exception, because there's some really important terms. And we talked about these terms at the last meeting, but I just want to highlight them and go over them because they're really important. So earned income exception, this has to be for a personal service. It has to be customarily provided in connection with the practice of this business. And it can't be any business. It has to be a bona fide business, trade, or profession. And yes, you have to say all three every time you talk about it because they're three different things. But we're talking about the practice of a bona fide business, trade, or profession, unless the sole or predominant activity is making speeches. So that's what the legislature has set up as the structure for the earned income exception. That term, bona fide business, is defined by regulation. And it's really important that we understand that under the regulation, you cannot have a bona fide business if the predominant activity is making speeches. So let's switch to, let me see, slide. Ellen, can you go to slide number 6 for me? There we go. Okay, so this is regulation 8932A. This is the regulation entitled Exceptions to the Honorarium Earned Income. And you'll see it says honorarium does not include income earned for personal services if the services are provided in connection with an individual's business, yada, yada. And the services are customarily provided in connection with the business, trade, or profession. So those are the things that we're looking for in every advice letter that comes in or any enforcement action. You want to know if this is for personal services, if those services are provided in connection with the business, and customarily provided in the connection with the business, and that the business is a bona fide business, trade, or profession. Now, down in Regulation 18932.1D, our regulation states a business whose predominant activity is making speeches is not bona fide for purposes of Government Code Section 89501 through 89506. And this is a really important provision to understand because you will hear people talk about bona fide businesses and legitimate businesses. And it's very important to understand that the word legitimate does not appear in the honorarium statutes or regulations. We talk about a bona fide business, and the legislature set this up for all of us to follow, and that's that you have to have a bona fide business, and our regulation has defined what you have to do to show that you're a bona fide business. It has to do with producing business records to show that you have an actual business that has tax records and expense and income records. Traditional, or if you have a trade or a profession that you have to provide documentation. But that provision D in that regulation is so important. It doesn't matter if you can show all of those things. You are not a bona fide business, trade, or profession if your predominant activity is making speeches. So, Ellen, can we please go just quickly to slide 6? I'm sorry, slide 5. All right, and this is another important definition that's in our regulations, and that's the definition of speech given. Speech given is a broad definition. It means a public address, oration, or other form of oral presentation. It includes the participation in a panel, a seminar, or a debate. Then there's some items that are excluded, and that's a comedic, dramatic, musical, or similar artistic performance. So you can see the definition of speech given is very broad, and that's necessary. I wish I could have had the time to bring in the reg packets from when these regulations were enacted back in the 1990s. It would go across this table because the commission and the public and the interested community spent a great deal of time hammering out these definitions and provisions. And it was actually a fascinating process for me to get to go through and look at the regulatory record on how these regulations were crafted and have largely been in place untouched since the 1990s, with some adjustments as the laws have sort of evolved and been reorganized. All right, so I think we've got our base background firmly underneath us, and it's important to understand. Another thing that I would like you to understand is the background concerns and purpose. And there's a couple of things going on in the honorarium ban. One thing is that if the payments for a speech or an appearance is categorized as income, that means that it is given to a candidate or an elected official or a designated employee, and it will not be a contribution, and it would not be a gift. It would not be subject to those reporting requirements or those limitations. It would be deemed income, and then it would be reportable on their statement of economic interest if it's a reportable source. So you could have an elected official who's making speeches and receiving income, and it might not get picked up on any of those three very important reporting categories that the Act has in place. And I believe that that was of concern at the time period that this honorarium ban went into effect. There were other concerns too, and that was the influence that these payments might have on the official, in part because they were going under the radar. So they could be very influential without the balance of the public being aware of it. The other concern, and this was something that Commissioner Wilson really highlighted, was that the honorarium ban also, while it addressed the corruption issues that were involved in the FBI sting that we talked about back in June of 2023, it was also directed at elected officials who were making speeches and being paid for the speeches completely legal under the law, but it was seen as profiting from their status as a candidate or as an elected official. And that was a concern, and that was something the public was having an issue with. And so that is part of the background for the honorarium ban. And I hope I'm not misstating your comments back from June 2023, but
I don't remember all those comments, but I'm sure you're not misstating them.
I have them all written down in case we need to check. So that's an important thing to consider, is that there were multiple concerns going on with the honorarium ban. And it's a well-crafted ban because you change one part of it and it sort of falls apart. You know, the legislature was very concerned that anyone could do an end run around the honorarium ban by saying, I've got a business and my business is making speeches. And yes, I went into a restaurant and I talked to two people and they paid me money, but that was just income because I was making a speech. So that was a big concern. There's also the concern that you have a business that has been in place prior to being a candidate. And you say it's a consulting business. Now you're a candidate or an elected official, and people want to be your friend or people want to influence you. All of a sudden you have all these new clients or new people who are willing to come and hear you speak and be their consultant. And so that concern was there too, that business could morph. And while it might have been a surgeon giving talks about a particular type of surgical expertise that they have prior to being an elected official, once they're an elected official, they might be getting invitations to come and talk about health policy, or they might be getting invitations to come and talk to a particular group about their particular area of expertise, and there might be no relationship there to what they were doing in the past. So there were concerns about abuse, and when we say abuse, we mean in a big sense of the word. And there were concerns about influence. So those were the things that were burbling behind the honorarium ban. Okay, let's see where I am in this.
And Ms.
All right.
Harris, just to clarify, so in that example that you gave with the surgeon, it's my understanding that that would be the sort of instance where this earned income exception would apply, where you have a surgeon who had an expertise in a specific area of medicine, right? They're a licensed physician, surgeon, et cetera, right? And they're paid to go speak on their expertise in medicine. That would satisfy these criteria in general, correct?
Great question. So if it is on that area of expertise and they have a surgical practice and the payments that they have received, their gross income and the hours that they have put into that surgical practice, if their total income and hours exceed that 50% threshold of the income that they're receiving for making speeches, then it does not, making speeches is not the predominant activity of that business, trade, or profession. But if you have a surgeon who is now a member of the assembly, let's say, and all of a sudden their speaking fees are here and their surgical practice income is down here, if making speeches is the predominant activity of that business, then for that next speech, for that anticipated speech, and this is done speech by speech. It's so cleverly crafted, I have to say. I really admire the people that did this. If that particular speech is going to put them above that 50%, and it's not at 50%, it has to be above 50%. If they are making more money making speeches than the rest of their entire income, then they cannot give that speech. Now, let's say their popularity for making that particular surgical speech has gone down and they're doing more surgeries, and I don't know how they're also in the legislature, but they're working it out. Once that is equal or less, they can make that speech. And that's why it's a speech by speech analysis. And that is why we have to include the amount that they're anticipating being paid as part of the calculation. It's really important. And it's important to understand when you look at these letters. Some questions we get are general, like in the informational advice letter that we received earlier. Can I do this in the future? It wasn't a specific speech. And some letters are very specific. And you have a surgeon coming to us, which we actually have that example, coming to us and saying, can I make this speech? This particular speech. This is my total income for the last 12 months. This is how much I anticipate earning on this speech. This is how much I've made on speeches in the last 12 months. You can do that analysis. They can do that analysis at home. You know, they don't have to come and ask us, but in that particular advice question, it was the next component that your question raised. And that particular speech was not their area of expertise. It was a general policy speech being given to a political organization. And so we took a look at that particular doctor's practice and their practice of making speeches, and we said this was not something customarily provided as a part of their business, trade, or profession. So in that particular instance, that particular speech, those payments, that payment would have been honorarium subject to the honorarium ban. That's how technical these are. So I want you to be very careful. When people talk about advice letters, you really need to know a lot of detail, and those advice letters are specific to that individual and often that speech. So to take those advice letters out of context and say, this advice letter said that, this advice letter said this, you need to know, really? Were we talking about a designated employee, or were we talking about an elected official or a candidate? You know, who were we talking about? Were we talking about a general question of, in the future, can I just give speeches all I want? And we're explaining what the rules are? Or were they talking about a specific speech or a specific event that they were going to be paid to go to? So just, you need a surgical scalpel when you're looking at the honorarium ban and these advice letters. But I feel like I'm Well, I
may
haven't
direct
gotten off
you
point
some-
because I'm answering questions.
Well, Senior Counsel Harrison, thank you for your excellent presentation. But from a historical context, I just want to clarify one
Please.
important point. You know, prior to the adoption of Prop 112 in 1990, that initiative was put on the ballot to target specific elected officials. And in the case of those elected officials, they weren't giving speeches to 2 or 3 people. They were giving speeches to large audiences of 100, 200, 300 people. And it was clearly legal. Then you had another tier of members who were really not targeted, who even after Prop 112 was adopted, were caught in legal problems because they were speaking to 2 or 3 people. So I think it's important to make that distinction. Prior to the adoption of Prop 112, there were specific elected officials in the legislature who were targeted in that regard. So I just wanted to clarify that for the record. So thank you.
Thank you. And that goes to the point that the honorarium ban was trying to encompass a number of problems. And the legislature and the voters really wrapped their arms around these problems and said, we're concerned about honorarium payments and we want to do something about it. And this is what they did. So,
And before we move on, I know Commissioner Baker had a comment. I want to make a quick clarifying comment or clarifying question. So we're talking about this threshold, correct? 50% or greater predominant activity,
Yes.
right? That is in the context of a bona fide business. Is
Yes.
that also in the context of a bona fide trade or profession?
yes,
Because I'm looking at the regulation, it just says a business whose predominant activity is making speeches
Which
is
reg-
not bona fide. That
oh.
would be 18932.1D. So for instance, a teacher, you know, they're engaging in a bona fide profession, right? And for the most part, I would say most of their job is making speeches, speech making. But they're not operating a business. So I guess similar to the surgeon example that I gave you, if that surgeon was employed by Kaiser, I assume their circumstance would be analyzed different than if they had their own private practice. Is that correct?
So you mentioned teacher.
Sure,
Teachers have their own provision.
correct.
So that there's a separate regulation that addresses teachers and when you're teaching.
So I guess surgeon, how would we address that if they're an employee, a licensed surgeon versus someone who
So-
has their own medical practice?
So typically, what we see is somebody that has a business, and that business is their medical practice, and a component of that medical practice is giving lectures. But let me double check that regulation, because I apologize, I don't have the full regulation, and I wish I did, and it would be better if I had that.
And then I believe the regulation that defines or addresses teaching just provides a presumption for when someone is considered to be engaging in the bona fide profession of teaching. It doesn't actually define when someone is acting within that bona fide employment. So basically provides a safe harbor, that sort of thing.
Yeah, it explains when a teacher is going to fall under these categories. And for example, you can't just say, I'm a teacher and I'm teaching classes whenever I go out and do this. You have to be a part of an accredited institution. Or, and I believe the state bar is another thing that you can be a teacher for. But you're
So
correct.
is it a presumption or it's a requirement?
I'm sorry, say it again.
I said, is it a presumption or a requirement as to teachers?
A presumption that teaching is a bona fide,
Well, a presumption that certain activity qualifies you as engaging in the bona fide employment of teaching.
no,
So I
there's-
read it as a presumption versus a requirement.
I will have to check, since
But
that
I
was
know
not the
Commissioner Baker
focus.
has been waiting for a very long time, so I want to let her speak.
Well, I
And then maybe we
actually
could circle
I
back
just-
to this.
Okay, so it
I'm
is a
happy to
presumption.
wait.
It
Please
is a-
take your time. Thank you.
It is a presumption, and at that time period, that was a way that regulations were drafted. And so it says an individual is presumed to be engaged in the bona fide profession of teaching in any one of the following circumstances. And then it lists those circumstances. I believe we would interpret that as what is required. And if somebody were to give us evidence of some reason why they're not following in this category, but they should be treated that it's similar to that category, that's where that presumption language comes in. But presumptions are tough in regulations. They create a little bit of ambiguity. But you are correct. I just looked at the regulation on the limitation, and that it does say in D, a business whose predominant activity is making speeches is not bona fide. And it doesn't also include trade or profession. I would have to research as to why they didn't also have trade and profession there, because I think it should be all three. It's all three throughout So we can check that, but thank you
So
for
I think it
raising it.
goes back to basically the historical context that Commissioner Wilson was talking about. I think part of, shrimp scam and all the convictions that led to this proposition, a lot of them related to shell businesses and shell companies. And they were really concerned, legislature, stakeholders were concerned that businesses would be created, speech-making businesses would be created, basically just so there was another avenue for providing sort of benefit to legislators. But
Correct.
I'm going to throw it over to Commissioner Baker.
There's no rush. If we need to have further discussion on this, I think the chair has actually raised a great point about, it just says business, and I'm glad that you'll be looking at, what about trade or profession? My question's going back a little bit to the surgeon example that you gave, where you gave the hypothetical that the surgeon may be asking, can I give this speech? And you said if that speech would take them over 50%, they can't give the speech. Am I right that what you might actually mean is you can give the speech, but it's gonna, you just can't get paid for it?
Correct. Correct.
Okay.
Thank you for that
Because
clarification.
they can still do speech. We still have the First
Yes.
Amendment. But if the real question is if they're going to be paid for it.
Absolutely.
Thank you. That was my only clarification.
No, I appreciate that very much because we wouldn't want to have any sort of impression that you can't speak. You can speak all you want. The honorarium ban is a ban on payment, and honorarium is a type of payment.
And can I interject real quick on the previous
you.
question from the
Of course,
chair?
General Counsel Bainbridge.
18932.1A talks about bona fide as to a business, but if you go down to 18932.1C, it then talks about bona fide as to trade or profession. So it covers all three, it's just broken up in different subdivisions in that regulation.
That's helpful. And you can go ahead with your presentation, Ms. Harrison.
Okay. We got a little off track. Okay, so we've talked about it a little bit, but I'd like to go to slide number 7, and that's the definition of predominant activity as we currently have it. So, and the language that's up here is as to the 12-month time period, but basically there's 2 time periods. Because you might have a new business or you might have a business that has been in existence for longer than 12 months. And so for those longer businesses, you're looking at a 12-month time period. The new businesses, you're looking at a 30-day time period. Generally, the requirement is for determining predominant activity is you're going to look at the 50% of the hours spent or more than 50% of the gross income of the business. If it's derived from the preparation or delivery of speeches, then the predominant activity of that business, trade, or profession will be speech making. So it's that 50% threshold we were talking about. So if you've got more than 50% of your total income, more, not equal to, more. If more is related to your gross income or your hours, then your predominant activity is speech making. It's really kind of a common sense approach. As I mentioned before, this allows for a rolling examination, which I think was sort of the brilliant part of this regulation. It's not static. They're not saying that as of this time period. They're saying we're going to look at each speech, each public appearance that you want to make, and we're going to apply this time period, and you can apply this time period. Let's see. Okay, so moving forward into the issue at hand. At the June 2023 meeting, the Commission discussed the application of the honorarium ban related to a particular informal advice request. And at issue was a local elected official who, prior to becoming a candidate, had an established book writing and promotion business, what was referred to in the request as a book talk business. And the official wanted to know generally if she could continue to be paid for book talks, i.e. making speeches, under the honorarium ban. And it was noted that her business had a cyclical nature in that she would have a time period where she would write a book, it would be under contract, and the book would be published, and the income stream would sort of be loaded up front, and then there would be a period of time where there was promotion of the book. We note that the fundamental nature of a business can develop But basically, this was a situation where the individual could kind of tie income back to that original product that was being created. So the advice that was issued was that the gross income for her business during the 12-month time period, and this was just general because there wasn't a particular speech, that if the predominant activity, if the gross income exceeded that 50% threshold, then any payment she received would be under the honorarium ban. It would be an honorarium payment and prohibited. But we said that when the income leveled out, when it was equal to or less than that 50% level, then she could be paid. And it was a case-by-case analysis, speech-by-speech analysis, where you'd have to do the calculation. Now, at that June meeting, there was a lot of discussion. There was a lengthy presentation and part of the slideshow that I'm showing you today. And some of those statements that the commissioners made, that you commissioners made, and some commissioners that aren't here now, they're very important. So I just want to refresh our recollection on that June 2023 meeting. And that's that Chair Manich at the time recognized that the predominant activity regulation was full square with the statute's ban. Also, that honorariums, it can be hard to distinguish what is earned income and what is an opportunity to give a payment to an official that is not going to get reported. And that is something we have to be very careful about. We had the discussion about the jurisdictional issue, which is that designated state and local employees and members of commissions and boards, that their honorarium ban is limited to what they have to a source that they would have to report on their statement of economic interest. Also, Chair Matich at the time commented that in the book talk context, payments could be subject to abuse, because if you took away that broad ban, anyone could be invited to come and listen to a book talk and make payments for it. You could bring people outside the jurisdiction in. Also, that elected official or that candidate could be invited out of the jurisdiction, and money could be funneled. And so that could be an easy end run around the ban. But we don't really have to worry about that because the statute states that if you're an elected official or you're a candidate, it is a full ban. Doesn't matter who the source is, doesn't matter where they live, doesn't matter where you live, doesn't matter where you're an elected official. You cannot have payments for making speeches, as harsh as that may be. There was a recognition that the advice letters, Ricci and Halderman, that were discussed at length at that meeting, that they were consistent. And the important thing to remember is that predominant activity requirement. It is fine for you to, these letters that are general, they will say, it is fine for you to make speeches if it's consistent with your business trader profession, and you've shown us that this is a documented business trader profession, so long as you do not reach that 50% threshold for that particular speech or appearance. Let's see. So then staff was directed to do something, I believe we were told to be careful and creative. We were directed, within the limitations of the honorarium ban statutes, to propose narrowly tailored regulatory changes to address the application of the honorarium ban to situations such as we had there, involving a long-standing business trader profession with less traditional hours and income cycles. And we were directed to do this without opening up the floodgates. And that is something really important to understand. Staff put a lot of time into this proposal. Because of the restrictions of the statutes, we are able to interpret statutes, but we cannot contradict a statute. We can't override a statute. That is not our provision. And so it's within the boundaries of these statutes and a regulation proposal that would not open up the floodgates. Very, very important. I was asked by Commissioner Baker, was I concerned that this proposal would create loopholes in the pre-notice. And my response was, we were always concerned about loopholes in the honorarium ban because it's so easy to do. It's a carefully crafted legislative package and regulatory package. And you tweak one little thing and it's all gonna go. So you have to be very careful. We looked at many alternatives and we'd say, yeah, well, maybe this would work. And we go, nope, easy end around, then you don't have an honorarium ban anymore. And we don't get to do that. We don't get to not have an honorarium ban. All right, so under this directive and this standard, staff has proposed the repeal and adoption of proposed regulation 18932.3. And wondering if I need to change the slides. No, we'll leave that slide there. All right. Just as a brief summary, proposed regulation 18932.3 reorganizes the current regulatory language. And that's on me because I thought it could be written more cleanly, more clearly. And the important change, the significant substantive change, is it allows for a 36-month time period to determine whether the predominant activity of the business, trade, or profession is making speeches under specified circumstances. And these are carefully crafted circumstances to not open the floodgates. So just to run through the regulation briefly, proposed subdivision A states the existing standard. More than 50% is the predominant threshold. Hours and gross income related to making speeches are the activities of the business, trade, or profession that are relevant to the determination. I would just note that the proposed language removes the presumption word that was in the previous, the current regulation, just to eliminate that ambiguity. And it consolidates the language. Subdivisions B1 and B2 provide the existing requirement that the predominant activity is determined prior to and including each speech-making opportunity, and the 2 current periods for making the determination. So it's got still the 30-day time period, the 12-month time period. Proposed subdivision B3 provides the 36-month time period. Again, you're looking at 36 months prior to but including the date of the speech for the period of examination, and this is applicable where the business, trade, or profession involves a proprietary item, tangible or intangible, created at least in part by the individual. And this 36 months is not an arbitrary time period. It's based on staff research into publishing arrangements. And we asked for input. We asked for input at the pre-notice. We did not receive input from the outside community, but this is what our research showed, and we thought it was important we provided the links to the materials that we were looking at in our memo. Additional requirements that were really a result of the discussion at the pre-notice, some concerns about the limitations and how this would work technically. This item, this proprietary item, must be protected by patent or copyright, such as a published book or a licensed computer software. And the individual must have an exclusive right or a shared right, but that individual must have some kind of legal right to this thing. And this is to avoid somebody saying, I'm thinking about a book, and I'm thinking about this book, and I'm going to have a book think talk, and I'm going to go out into the community. No, it has to be a little more serious than that so that we can take a look at this. To minimize the potential for abuse, the 36-month period applies only where the business, trade, or profession has existed 12 months prior to the time period the individual became subject to the honorarium ban requirements. And this is important so that you don't have something that's created and you can have those abuses. We want to have that long-standing business requirement that the commission was concerned about when we were given that directive. Proposed subdivision C has some clarifications that speech is the preparation of the speech is included in the term delivery of speeches, and that the hours and gross income include any anticipated or promised or received income and any hours spent or anticipated to be spent for the particular speech-making opportunity. This is picking up language that's in the existing regulation and just sort of reorganizing it. So as noted, the proposed changes address the Commission's directive to interpret the honorarium ban statutes and not open the floodgates. This is, as Commissioner Baker asked me at the at the previous pre-notice meeting, this is an expansion. This will allow payments for speech making that in the past would not have been allowed. So this is an expansion, and so we do need to be careful and limited about it. I do have a PowerPoint presentation that runs through an example. If this would be an appropriate time, I can walk through that right now.
I think that'd be helpful unless any commissioners have comment before that. Go ahead.
Okay, Elwin, can we switch to the example presentation, the non-blue? There we go. All right, so this is a comparison and application. And just for ease, I just looked at gross income, but it's equally applicable to hours. Let's see if I can control it. Oh, I could. Okay, so we talked about the earned income exception, and that's what predominant activity is all about, right? It's all about that earned income exception and whether or not it's going to apply. And just as a brief refresher, payments are earned income and do not meet the definition of honorarium, but they must meet all four criteria. Must be for a personal service, must be customarily provided in connection with the practice of a bona fide business, trade, or profession, unless, so you can have a personal service, you can have it customarily provided, and you can have the practice of a bona fide business, trade, or profession, unless the sole or predominant activity of that business, trade, or profession is making speeches, all right? So then we go to a comparison of how predominant activity is going to be defined under the current regulation and under the proposed regulation. So under the current regulation, if you have a business that has been in business for more than a year, you're going to look at that 12-month time period. Under the proposal, if you fall into that particular category where you have a proprietary item and your business existed prior to the time period that the honorarium ban applied to you, you have the ability to look at this 36-month time period prior to and including the date of the speech. Okay. So
Commissioner
here's-
Ortiz?
Thank you. When you're looking at the the proposed 36 months to see whether there was more or less the 50% threshold, how are you going to look on the 3 years? You look every year or you look on the aggregate?
Good question. You're looking at 36 months back. It's a look back. So just like the 12-month period, you take the anticipated time and income that you're going to get for that speech, and then you calculate your total income and your speech-making income for the 12 months prior or the 36 months prior.
I understand the 12 months because that's a year, a financial year. But when you have 3 years, then are you going to aggregate the income of those 3 years to see whether that speech will push up that person above 50, or are you going to look at the individual years of the 3 years?
You're going to look by month. So it's a 36-month window that you're looking back. Just like now, it's not a fiscal year right now. It's a 12-month look back. So it doesn't necessarily run on your fiscal year. It's 12 months back. It's a rolling examination.
Okay,
Does
yeah,
that-
because I was trying to understand how you were going to decide that, But comment.
Yeah.
Your presentation is wonderful. I'm very grateful because I read all this stuff over and over and over, and I was trying to figure out where all this. But all your definition, the historical background, everything for me was very instructional. Thank you. Thank you.
Thank you. All right, so now we have a hypothetical. And like I said, this is based on gross income facts, but it could just as well be hours. So we have Jane Doe. And Jane Doe is an established author running for office January 2024. In January 2022, and you see the months important because we're going back 12 months, not a year, she signed a book deal for a new book and received a $40,000 advance. So her total income was $40,000. In 2023, she published the book. She received royalties, $24,000, and another $16,000 for 8 speaking events. Total income, $40,000. In January 2024, she's a candidate now, she wishes to be paid $10,000 for a speaking event, publicizing her book. And let's see how it would apply. Okay, so under the current regulation, looking back at the past 12 months, you're going to have 2023, she's got $40,000 in a total income. She's got $10,000 for this speech event. So the total income for the business, including the speech event, is $50,000. You look at total income from making speeches, it's $26,000. That's going to be more than 50% of her total income in the past 12 months. So that payment, that $10,000 payment, is going to be prohibited honorarium. Now, if she were paid less, the calculation would change, and the answer may change. And that's why we say in our advice letters, that's the standard, it's that 50% standard. It depends on how much you're getting paid for this particular event and how much you've been paid in the past. All right, now under the proposed regulation, we have a different result, because in the past 36 months, you're going back further, and you're going to look at 2022, $40,000 in advance, 2023, $40,000, which is royalties and speaking fees. She's getting speaking fees now, so $80,000. With the $10,000 for this speech event, total income over this time period is going to be $90,000. Total income from making speeches, $26,000. That is less than 50% of the total income of $90,000 in the past 36 months. The payment is not prohibited honorarium, it's earned income. So this is the change. And Commissioner Baker, this is like specifically for you, because I know you wanted to see how this would play out. This is the expansion. So you're going to have a candidate that can make that $10,000 speaking event speech under this regulation that under the current regulation could not. So just so we're clear on that. And any questions about that example?
Commissioner Baker?
Thank you so much. I want to echo Commissioner Ortiz's praise for how clear this is, and I'm very grateful for it because it does help no matter how much you read well-written memos and drafts. My question about this is, can a candidate under either scenario, I guess under either scenario, can Jane Doe, under the existing rules, so 12 months, have still gotten the $10,000 if she'd pushed the speaking event out? Let's say, let's not do it in June of 2024. Let's do it in August of 2024, because then the 12-month period has changed and I've had other income come in, so I get below the 50% threshold. Is that one way right now, if there's no amendments, that a elected official or Jane Doe here could have still done the speech and gotten $10,000?
So really the thing that you're looking at is, did the total income go up such that the fees for that speaking engagement isn't going to push them above the 50% threshold and make the predominant activity of the business making speeches. So it's sort of like the
and if
surgeon's
the candidate,
example.
if the elected official can work with whoever the person is and say, well, let's not have this event now, let's have it in another quarter, and then I'll be able to take the money.
Yeah, another way I think we could put it is promised income going to be counted towards the honorarium threshold? So if someone says, let's do a speech, and Commissioner Baker, please interrupt me if I'm mischaracterizing what you're asking here. But if someone is offered to make a speech in June, but they look at their numbers, it's going to be an issue, right? And they say, well, why don't we do this in September? And an agreement is made that they're going to receive a payment in September. Is that correct? Is that correct, Commissioner?
Yes,
Baker?
I mean, not just the payment, but that the event is actually, the thing that would trigger the difference between getting to keep the 10 grand and not is this negotiation that I'm gonna change the time period, and between June and August, I'll make other money that's unrelated to speeches that will change the math.
As long as you have that income in the formula, you're looking at 12 months and you're looking at the anticipated income for the speech, and you would have to have that income raise if you wanted to make that speech for that amount. So
So I
yes,
think the
you're
answer to
looking-
the question is yes, that's one way under the existing rules, which means it's going to be the case for the changes.
I think the tricky part is making sure that your total income for the business that is not related to speech making goes up. And that
Yes.
is what the commission, when they wrote this regulation, that's what they were looking for. So if you're a surgeon and you're doing your surgical procedures and you're speaking on the side, and it's a side component to your business, okay, keep making speeches. But if you are not doing any more surgical procedures, but all of a sudden your speaking is your business, well, then you have a speech-making business. And businesses morph, they change. And they especially change when you take on a big role, like being an elected official. And you might not be able to put that time into your surgical practice, but guess what? You speak all the time. And that is what the legislature was concerned about.
Okay, thank you. I think that does answer my question that, you know, there's still ways in which an elected might be able to take, Jane Doe could take the 10 grand. It's just, she'd have to push out the event and earn other non-speech related money to change her income level. Takes a lot of thought. And the period we're looking at changing is 12 months versus 36 months from doing that. So thank you.
You're welcome. Are there other questions?
Commissioner Wilson?
Yeah, I think you've answered this one. This is more of a technical question, but let's say this regulation is implemented and someone inadvertently makes a mistake in calculating whether they're officially engaged in a speech-making business. What are the potential consequences for that
So-
miscalculation?
So that is addressed in the memo, and there is a provision in the statute where you can return the payment within a certain time period under certain conditions.
Thank you.
And thank you for bringing it up at the pre-notice, and that's why it's in the memo.
Excellent. Well, I want to move on to public comment in just a moment. I kind of want to lay out for the other commissioner where I'm at here. I've gone back just like, legal division staff. And, even before I go there, I want to say, I think legal division's done an excellent job on this. This is one of the more complicated areas of the act. I can tell you from personal experience, I've had to advise people in this area. You got to look at advice letters from all over the place, all different sorts of fact patterns, and then apply them, all right? And one of my goals as chair is to make it easier for people to run for office, right, and hold office. And I think if we're asking a public official in a small jurisdiction to go on LexisNexis or Westlaw and look at advice letters from the 90s, I think that's going to be difficult, right? It's just going to be another barrier to entry for people to participate in the political process. With that said, so, like I mentioned, I went back, I looked at the June 2023 meeting. I thought the chair, eloquently explained what the voters' intent was in adopting this ban. I think the voters intended for it to be a broad ban. So initially, I was hesitant, skeptical of expanding it, right? I feel like our role as an institution is not to pick winners and losers. It's to fairly and effectively further the purposes of the act within our statutory authority. With that said, again, I think legal division did an excellent job threading the needle here. What they did is rather than pursuing a solution that was tailored to address a specific individual sympathetic set of facts, right? What we did was better define when a business's predominant activity is speech making. I think it makes sense that we're looking at a 36-month period. Like you threw together in the memo, you pointed out in the memo, we didn't just pick 36 months out of the air, right? You did extensive research looking specifically at these towards sorts of cyclical businesses, right? To see what the patterns are so we could come up with a appropriate period for analyzing. And that's something that I know legal division has gone back and forth on and given a lot of thought, and this is where we arrived, and I really appreciate that. I also think we have to acknowledge that we received public comment, and I found the policy arguments in the public comment to be extremely persuasive. The public official who Mr. Winnick is representing, I think she's exactly the kind of person that we want in public service, right? So I think that's something that we want to consider. But obviously, we have to stay within our bounds, within our statutory authority, right? And I'm hopeful that, there's situations like this, there's other situations perhaps on social media with influencers, that sort of thing, where these honoraria rules, it's kind of unclear how they would apply, but we don't have the authority to step in and fix them. So I'm hoping the legislature can identify those sorts of issues and hopefully fix them, and then there's no sort of challenge as to whether we have the authority to do that. With that said, I'm going to add one additional thing here, and then I'll be done talking, because I swear I could talk about the honoraria prohibition all day, because there is a lot to unwrap here. I'm a little bit concerned about the removal of the presumption. I'd like to hear, once we receive public comment, I want to circle back on how removal of the presumption is going to operate with the other regulations we have that deal with trade and profession, right? Because we have this presumption of when predominant activity is speech making. We also have a presumption as to when teaching, right, is bona fide. If we remove that presumption and just say that a business, trade, or profession is predominantly speech making, if we meet these thresholds, does that reconcile with another regulation that says if you're a licensed teacher, right, if you're working for the UC, you are exempt, right? You're engaging in a bona fide profession. It would seem to me that those may conflict. So if you'd like to address that now, you can. I'd like to, get to public comment as well.
Sure. No, they don't conflict. And the presumption at that time was a means of drafting that is disfavored now in the legal writing community. When you have the term presumption, it really just adds ambiguity that's unnecessary. And it doesn't add anything. If I could redraft every honorarium reg to bring it up to current standards of legal writing when you're drafting regulations, I would do so. Part of the reason why this was reorganized, it might have been simpler for everybody to just stick in a 36-month time period and leave the rest of the regulation alone. That might have been an easier thing to present as well. But I felt that for ease, in any candidate or elected official or designated employee to go and read this regulation, that this flowed a little bit more smoothly, because it is something that they need to be able to read and apply. I think the presumption just adds a term that doesn't bring any value to this regulation. And I don't see a conflict, because it really is just sort of like a throat clearer that was added to the regulation. It was kind of like in the old days when lawyers would say 3 words instead of 1 when they meant just 1.
Sure.
So that was a cleanup that really isn't a substantive change here. So I think that that's important. I would also like to encourage anyone out there in the community that has this question to not do research on past advice letters, because those advice letters may not and probably do not apply to their situation. If they have an advice question, come up to the modern world, send in an email, make a phone call, request formal advice. We're here to provide that advice every day. We don't get very many honorarium questions. This is the only honorarium issue that I have worked on in the nearly 10 years that I've been here. And that's because it's pretty clear. And I think you asked, are we having enforcement issues on honorarium? No, we're really not, from my research, because it's such a clear, broad ban. And Elwin, could you bring back up the blue slides and go to slide 1? When you have a ban that is this total and this clear, people get it. And I think the legislature meant it when they wrote it this way, that we are going to have this broad application of a ban so that everybody can know where they stand. You don't get honorarium payments. That was purposeful. And so I wish, instead of you looking at old advice letters, you had sent your folks our way, because that's what we're tasked with doing. So I'll allow you, I think you want to move on to public comment unless there's other questions.
Unless Commissioner Baker?
And I don't know if our colleagues had other questions. I had 2, and I see this is the question time before public comment. I'm trying to have you re-clarify or just state again, once, let's say Jane Doe is elected, that this change isn't going to create a new opportunity for an elected to create a business on the side that they otherwise couldn't have done before. I think you said something about this really applies once the honorarium ban would have kicked in. Can you state again or clarify for me, please, what you meant when you were saying, something can't happen because the honorarium ban will have kicked in and that has an impact on it? Because I'm imagining a situation, we're going to pick on the Senate this time. We always pick on assembly members, and I'm a little defensive about that, where there's a senator, Jane Doe gets elected to the Senate, and she's like, okay, I got this 3-year look back now. Let me see how I can use that to create something new that I otherwise didn't already have. That's where I'm going with this, because I think you alluded to it, but very, very briefly, that this change to 36 months from 12 years doesn't create more of that possibility.
Okay, so we have the 30-day, we have the 12-month, and the proposal is a 36-month. But the 36-month only applies if this business trader profession was in place 12 months prior to the individual being subject to the honorarium ban. So if there were a candidate, it has to have been in existence 12 months prior to them becoming a candidate. And that is to contain this. This is, another thing to put a safety on this expansion. Because otherwise, you're right, somebody could be in elective office and say, I could create a business right now. And 36 months, well, I've only got 6 months to look at. What do I do? We didn't want that type of situation.
Thank you. That helps me tremendously. The second question is a lot fuzzier. And it is to ask if you and the staff would have done this at all, because or if you have reservations. The June meeting, I think we were trying to say, at least this is how I remember it, and you've portrayed it very well. We are sympathetic to the particular individual who's come up. Can you please go look at if there's a change that can be made that A, we have authority to do, but also B, that we should do? And I hope there was an invitation for staff to come back and say, yeah, we have authority to do this, but I don't think we should do it. And that's what I'm trying to ask you, is if there is, the extent to which you're comfortable articulating as best you can, is this something that the staff is recommending? Yeah, this is appropriate to do under the new world of how books and speeches happen, or we wouldn't have done this had we not been told by the commission that you have to go out and change something.
So I think Dave has something to say, but before you say that, Dave, I just have a really quick cleanup comment. My research showed this is not a new world, that books and book talks are old. Mark Twain, he did books and book talks. So it's been around for a long time. And this was vetted back in 1990 when they went over these regulations. There was public comment from a travel writer who was a designated employee and was concerned about how this would affect her business. So it's not something new. This is old. And I know at the June 2023 commission meeting, there was a sort of a feeling that this was something new, but it's as old as the hills. So with that.
Dave Bainbridge, General Counsel. I'll speak for the legal division staff. I think we're mostly in agreement on this. Our feeling previously was that because the honorarium ban was adopted by a ballot measure, and because it is such a broad prohibition and a definitive prohibition, that any broadening of the rules, we thought it would be best done by the legislature. That was our position then. That's my position now. The commission asked that we try to come back and accommodate this particular situation where you have someone with an existing business. This is what we came back with at the direction of the commission. I prefer to, when we're making these sort of changes, put it to the legislature as opposed to us making a law a little bit more permissive, which is what this would be doing, granted in a minor way. I do think it's within the commission's authority, specifically because the statute calls out that the commission can interpret this term and define it. I think it's a reasonable interpretation, but overall my position would be that this is best left to the legislature.
Thank you.
Any other comment before Commissioner Ortiz?
Thank you. I want to reiterate again my appreciation for your presentation, because understanding the law, the existing law, and the restrictions and all that was very important, because the letter that we got, what we call the WUNUC letter, whatever is it that we call it, it was persuasive, as you said. But I think General Counsel and the chair suggested, and I agree, that perhaps they should be looking at a legislative solution, because right now we're constrained by existing statutes as to how we move forward.
And I would just comment, Mr. Winnick's here and he'll speak for himself, but I would just comment that that letter contained misstatements about the law. And so we need to be very careful when we look at that letter. And I think the persuasive part is the story about an elected official who has a business. But that is really up to the legislature, as Mr. Bainbridge is pointing out. But do be very careful. Both the letters, I believe, did not follow the directive that we were given as staff to stay within the boundaries of the honorarium ban statutes and not open the floodgates. And these were proposals that were brought up in June 2023 and rejected. And there was no input at the pre-notice, and now they're being brought up today. And so I think that we need to be careful about that. And I need all of you to pay attention to what the statutes say, because that is our ultimate authority, and we cannot go beyond that.
Absolutely. And as Mr. Winnick comes up, if you could, you don't have to go in too far depth, but if you're going to say there were misstatements in the law, if you could identify those so, he can respond to those as well as any other public commenters, just so all the commissioners are clear.
Sure. So, first off, to say that if the elected official were a state official, I think it's on page 2 at the top. Were she a state office holder, any payments from outside her jurisdiction would not be considered an honorarium, and this would not even be an issue. See FPPC Staff Memo footnote 9. Footnote 9 is this honorarium ban that clearly says an elected officer, state or local government agency, shall not accept any honorarium, and that the jurisdictional element of being limited to the source that you have to report on your SEI, that is only for a member of a state board or a state commission or local board or local commission or state or local designated employee. Now, this was fully covered in June of 2023, and yet this statement is back here in this letter, and I don't like misleading statements.
And Ms. Harrison, I apologize for interrupting. I just wanted to identify the specific items so that Mr. Winnick could address them. Were there any other?
You just want me to not say anything?
Well, no, you can absolutely respond to public comment and
I would
provide the
say-
relevant law.
So, let's take a look. All right, so one of the questions was, could we define earned income exception as found in Regulation 18932 to exclude personal services from a business, trade, or profession that involves a proprietary item created in full or in part by the individual, as consistent with Halderman and Donald advice letters? No, there's no statutory authority for that. And it's, as far as citing advice letters and saying this is consistent with them, no. And so I find that problematical. There is no statutory authority to define earned income exception to allow for payments for personal services where there's a proprietary item involved for the purpose of a business, trade, or profession, da-da-da-da-da. So this is in direct contradiction to, let's see, can we go to, Elwin, can we go to the oh, I'm sorry, I'm pressing the wrong way.
And Ms. Harrison, I'm going to interrupt you. I'm just going to move on to public comment. I assume that the public commenters will address, the items that you've identified.
Okay, and I tried to be thorough and address with the statute some of these proposals, but I would just say the proposals that were presented in the 2 letters are in direct contradiction to the statutes. They are beyond our authority. If they were followed, they would open the floodgates. They're an incorrect interpretation. And we were asked to spend time on this, and we did spend time on it. And I think that shows. And so I understand that you want to hear from other
Agreed.
people.
I
besides me.
absolutely agree. It does show. And I think you did an excellent job threading the
Okay,
needle, like
thank
I said. Public comment?
Good morning, Mr. Chair. Good morning, members. Since we're talking about misstatements, let's talk about.
Could you
Good
please
morning
introduce
again.
yourself?
Yes, Gary Winnick, representing Julie Lifcott-Himes.
Thank you, Mr. Winnick.
Thank you very much. Since we're talking about misstatements, let's talk about some of the staff misstatements that we've had here today. At the hearing last year, staff discussed the advice letters that were mentioned, and staff explicitly said they thought those advice letters were wrong. But the problem is those advice letters have not been depublished. And Ms. Harrison just said something extraordinary today, which is don't live in the past in terms of advice letters, live in the future, I think she said. The problem is every elected and public official in this state is held accountable for every advice letter that's out there. They're used in court, they're used by the enforcement division, they're used in advice, they're used for every legal area there is to provide guidance. It is the commission's one of their primary tools, the way you guide the behavior of public officials. So to say, don't look to any of the advice letters we've put out, particularly ones that haven't been depublished, and there is a process to depublish advice letters, is an extraordinary statement for a member of the FPPC staff to make. The advice letters do matter. They do provide part of your body of law, and they are followed by the regulated community. And there are a number of advice letters that address this situation. And so my overall point here today is that this is not an expansion of the law. This is a contraction of the law. And that's why I am opposed to it, and that's why CPAA is opposed to it. I'll let them speak for themselves. And the reason it's a contraction of the law and not an expansion is because by adopting this regulation with this accompanying conversation, you are therefore invalidating these prior advice letters that provided the expansion or the clarification of the definition of speech given and of earned income under the exception. So specifically, the FPPC has advised that an FPPC commissioner can be paid to do a radio show. I don't disagree with that advice, but that would no longer be possible. Under the Leach advice letter, a public official could be a seminar leader, and those are not considered to be speeches. I agree with that advice letter. That would be repealed as of today. And under specifically the Ritchie advice letter from 1997, that dealt specifically with presentations related to a book author. Now that obviously is applicable to this situation that would no longer be the case once, if you adopt this regulation today. So if you adopt it, we are now contracting the ability to do it. And why would we want to do that? You know, we've talked about the facts at issue here, but this is just one example. This is a person who, in the advice letter that I sought, the FPPC staff defined as having a bona fide business. So that's not really in dispute. That's already happened. It's a long-standing business. It's 9 years that she's been a public author. It's long-standing. And it's clearly not designed to, the rule prohibiting that is not meeting the goals that the honorarium ban is supposed to have. Commissioner Wilson was exactly correct. When there were scandals in the 80s and I believe early 90s, there were people setting up shell companies to receive honorarium payments. The truth, though, is, you know, it was not designed to hit businesses such as writing a book and being a successful author. And the length of time that you're successful as an author should not matter in determining whether or not it's a speech. So if Dr. Spock, for those of you of my generation who remember Dr. Spock, wants to publish his book, which was one of the most successful books in history, and wants to keep giving lectures to sell his book many years after, which he could easily have done, we're now basically saying that he can't earn an income and become a public official. And the chair mentioned that we don't want to put in place rules that discourage people from being in public service. We want to discourage people from from receiving payments that are going to influence their official actions. That's what the rule is designed to do. So targeting someone that has a pre-existing business, which is indisputable here, and saying, well, look, if you don't publish a new book every 3 years, that's a New York Times bestseller, that you can't serve in public office, doesn't serve any public purpose. And so this law it's going to prohibit people who have a successful book from serving in public office. And there's no reason to do it the way that it's been proposed by staff. Because, first of all, they said we don't have the legal authority to do it under the statute. That's a new opinion because all the prior advice letters said you did have the ability to define speech given and to expand the authority, or sorry, the definition of earned income.
Mr. Winnick, just a couple clarifying remarks. So in Ricci, so I was up all last night reading all the advice letters. You did a great job pointing out all of them. I think we had 15 or so in there. Ricci, it did point out that the predominant activity, I believe, couldn't be speech making. The other ones, I don't know if we had that sort of emphasis in it. And then, as was pointed out at the June 2023 meeting, there's subsequently been advice letters to the contrary, right? And that's one thing that concerns me about the advice letters, is they're all over the place.
Well, I appreciate that, but then the commission should depublish advice letters that it doesn't think are valid anymore and that are put out there to guide the commission's or the regulated community's activities.
And
I assure
absolutely
you, as
appreciate-
I'm sure you know, Mr. Chair, since you've provided advice, we all look to the advice letters for that guidance. And so if there's a subsequent advice letter that has a different take on it, that doesn't mean the previous advice letter is repealed unless that's formally depublished, which some of them are and some of them aren't. But again, I think my point remains the same. Whether you want to say Ricci is great or you don't like Ricci, Ricci is out there as an advice letter, and the spirit and the purpose of that is still valid for this particular situation and for the issue as a whole. You know, do we want people like Julie Lithgott-Himes in office? The chair said himself, yes, we do. Then why are we banning someone who has a longstanding business completely unrelated to her public service? She talks, her books are about parenting and gender equity, and most of her talks are out of state. And so there's really no connection between that and her public office. And oh, by the way, if someone wanted to influence her or anyone's service in the public, they could pay for the book to be written. They could pay for her to come perform some other service. You know, when someone wants to commit a corrupt activity, there's a lot of avenues, unfortunately, to do that. So speeches, although obviously covered by the statute and are important, are not the only avenue to preventing conduct that we want to discourage. So then we're weighing conduct we want to discourage versus allowing people to serve in public who have a means of earning an income that are tied to something very specific. I think staff in some ways answered their own question because they came up with a definition regarding proprietary items created. And so staff has talked about not opening the floodgates. I agree with that completely. But they've already come up with part of the answer to that, which is narrowing down the definitions to a proprietary item created. So if you have a longstanding business for a proprietary item created before you get into office, that's a very narrow category of people. I think greatly reduces the likelihood of there being the type of influence and conduct that we're trying to prohibit here. And so, again, I'm asking you to reject this particular solution and to creatively work to come up with a different solution that would allow people that we want to serve to be able to serve. Staff has claimed that they don't have the authority under the statute, but this is just this staff's opinion. The staff in 2008 and the staff in 1997, when these other advice letters were put out, thought they did have the authority. So it's always a question of interpretation. But ultimately, that decision lies with you as commission members. Staff can make recommendations. They did excellent research. I don't have any criticism with them for providing the option they thought was best, but ultimately the policy decisions are made by the commission itself, not by staff. So if the commission thinks, as it did last year in the hearing, that this type of situation should not be prohibited by the regulation, then we just need to send staff back to come up with other creative solutions and let them know that you think that there should be a more creative solution. And your job and your authority is to interpret the statute. So I agree something can't conflict directly with the statute. But again, in 2008 and 1997, staff thought none of these definitions of speech given conflicted with the statute itself. And again, it's just very common statutory interpretation. An administrative agency has the ability to interpret specific terms in a statute. One of the terms in the statute is speech given. So you have the authority to define that term and to provide greater clarification for what that term means. And so I would encourage you to do that. again, we have a pre-existing, longstanding, excuse me, bona fide business that's an issue here, and someone who deserves to stay in public office. And I think the commission's regulations should be able to find a way to find a common sense solution to that while still meeting the public service goals. So thank you very much. Apologize if I took too much time.
Appreciate that. Thank you. Any questions or comments from commissioners? Hearing and seeing none. Oh, Commissioner Baker. Sorry, I didn't see that there.
That's
Go ahead.
okay. And I welcome and I'm always very interested in my colleagues' thoughts. I'll just say this. I appreciate the very robust public comment we did receive and the solutions that were coming forward. For my part, this discussion has made me comfortable with not changing anything at all. The most I'm comfortable with changing is the proposal that staff has put before us. Because I do believe it's within our authority, and I believe it is as limited as it needs to be, because it is expanding the ability of people to make money and collect an honorarium where they didn't have it before. And I'm sympathetic to the particular individual that gave rise to the discussion in June. There are a lot of rules out there that we have that might make people less likely to run for office. Just having a Form 700 and having to disclose your income and, making less money than you would if you stayed in the private sector. But I don't believe that has never persuaded me against doing something that I think keeps corruption and abuse in check. I'm comfortable with the staff proposal today. I don't intend to be the one to move it, but based on the discussion that we've had, I also could see where we don't change the rule. And if there really is a groundswell and the legislature wants to change it because they believe it's time to do that on behalf of the people, that may be anything further has to come from there. I just wanted to share that with my colleagues for transparency as we have these discussions.
Well, that's helpful. Any other? Sure. So I'm just piggybacking on what Commissioner Baker said. We looked at the legislative history, or voters' intent here. They wanted the ban to be executed broadly, right? So, I'm immediately skeptical of any sort of expansion. I think the legal division did a good job doing this within a sense or in a manner that is within our statutory authority, the regulation that's before us. I can tell you personally, again, like I said, I really appreciate having someone like Mr. Winnick's client in local government. I think if it was up to me as a person, if I was a legislator, that's something that I would want to figure out some sort of legislative solution that does not open up the floodgates, right? But as Chair Matich and the commission felt back in June 2023, they had significant concerns with going that far. And the reality is they even had some concerns initially with our authority to go as far as we're going today. So I'm supportive. My concern, and this is completely on me, is the language that we're using now with removing that presumption. So for another example, I've just had a lot of examples pop into my head. So you have a surgeon, like I said, who's come up with a new procedure, right? They are licensed, right? So they're presumed to be engaging in a bona fide profession or trade. Moving forward, they don't do surgeries, but they do instruct doctors. They do presentations on that sort of thing. If we change the language here and that surgeon, their work moving forward, the income they receive for those sorts of advice, guidance that they're giving is more than 50%, they would be in violation of the honoraria prohibition, or would they not be? That's what I'm confused about here. And like Mr. Winnick pointed out, all officials from all across California, their representatives, et cetera, city attorneys, they go ahead and they go years back, they watch these commission hearings for these sorts of answers. So I want to make sure if there's confusion that they can go and seek the correct guidance in that sort of situation. So if that was the example, Would that be permissible? My main concern in a nutshell is I'm concerned if we remove presumption, you are effectively saying that any business, I should say, any trade or profession where more than 50% of that activity is speech making is going to be exempt, is no longer going to fall under this earned income exception. Is that the case or is that not the case?
So I think what I hear you saying is, what is the impact of having presumption in the regulation and not in the regulation?
Sure.
So my comment, and I don't know if Mr. Bainbridge has anything that he wants to add, is that right now that is not a purposeful term. We have never had anybody try to rebut the presumption with outside criteria. And that presumption opens the door to that kind of ambiguity. So we would actually be making a clearer regulation that says this is the definition of predominant activity. And by eliminating that ambiguity, you always make a better regulation. And that's why it's the accepted standard now. Does that make sense?
Sure. I mean, as I understand it, it's a presumption right now. So someone could rebut that presumption. Let's say someone is a yoga teacher, right? And then more than 50% of their work is providing oral presentations, right? They're not going to meet the presumptions under the regulation that addresses teaching, right? Are we saying that de facto they are exempt or not going to fall within their income exception because of that?
I think that the term presumption and how it's applied under the current regulations it just opens the door to some wishy-washiness, whereas this is quite clear. This is saying this is the standard, so you have that clarity. You don't have to think, oh, my business is presumed to have this or not have this predominant activity. It could go either way. You could think, oh, I don't have a predominant activity of speech making, but it's just presumed. So you want that clarity. You want to have the clarity in the regulation.
So why did we adopt the regulations of presumption initially? Do we have any?
It was a drafting practice at the time, and you'll see it sprinkled throughout. It's sort of like when the legislature used to use which, where they should use that. It's a similar issue on that level.
So it wasn't to give us flexibility as to teachers
that is my
that.
perspective, but I don't know if Mr. Bainbridge wants to add anything to that.
As I read it, I don't think presumed in this situation adds or changes anything. I think there are situations where adding a presumption does, because, it could be rebutted. I agree with Ms. Harrison here. I think the use of the term, she's gone through the file. I haven't looked at it in great detail, but reading the plain language, I don't think presumed changes the meaning of it. I don't think there was ever an intent that you could overcome this. It's presumed if you hit one of these, if you hit one of the ABC, but they don't really mean presumed. They mean it will be if you hit one of these three criteria.
And it also will not be if you don't hit one of these three criteria.
Right. That's how I'm reading it.
Okay. So in those two examples, just so we can give real world examples to the public. So you have a surgeon, right, that I laid out first. Then you have a yoga teacher who's an employee, does not have their own business. So how would we'd analyze them the same prior to adopting this new regulations we would afterwards, correct?
Yes.
Okay. And what would that analysis be?
So if you forgive me, if you could walk me back through your hypothetical, because I'm afraid that I don't have the details.
Yeah, no problem at all. So you have a surgeon who's cardiac surgeon. They've been practicing cardiology for, let's say, 20 years now, and they came up with a groundbreaking procedure that's now being used by all of their surgeons in the area, right? And they are paid to come and speak about this specific groundbreaking procedure. So they're not going to speak on healthcare policy. They're not going to speak on, for example, housing, something like that, that may fall under their role as a city council member, public official generally, right? They're there to speak about their specific expertise.
Mm-hmm.
They do not have a business, but they are a licensed physician. They're paid to make these speeches. So if the income they're receiving is over 50% for presenting on that expertise, is that going to be a prohibited honorarium? Is that going to fall under the earned income exception?
So when you say that they're a licensed physician, but they don't have a business,
Correct.
I kind of take issue with that just from the research that I've done. You know,
Okay.
typically they're part of a practice and they might be an employee, but they have income, and we would look at whether or not that income, that total income for the entire business or the entire money that they're making, whether or not 50%, whether or not greater than 50% is coming from making speeches to determine the predominant activity. So if their predominant activity, more than 50% making speeches, gross income, or hours, then that will be their predominant activity, and the payment for that next appearance or speech would be a prohibited honorarium.
Okay. And that's the case regardless of whether they have their own medical practice or they're employed by Kaiser, for example. Because in the latter example, it'd be the profession.
It gets a little bit more complicated when they're employed by Kaiser, because you would have to look at the, terms of their profession, what's under contract, what they're being paid for, is it customarily provided? You'd have to do that full analysis. Typically, if you're employed by Kaiser, you're not going out and making side income from making speeches. And so it would fall, it wouldn't be your primary duty.
Okay.
So it's a little complicated, but I think I've answered your question.
Okay. I think you have. So the analysis would be the same. In the example of a business, we would be looking at this 50% threshold. But in the example of trade or profession, we would be looking at something else. We would be looking at customarily given as to that trade or profession in the case of an employee.
So we go back to that earned income exception, that the slide is up, and it's personal services customarily provided, the practice of a bona fide business, trade, or profession, so it's looking at all three, unless the sole or predominant activity of the business, trade, or profession is making speeches. So that's the fundamental rule that we'd go back and look at, is the predominant activity of that business, trade, or profession making speeches. So you can't have a speech-making business, trade, or profession and receive payments under the honorarium ban.
And then we have a regulation that further clarifies it and says that specifically as to businesses, it talks about predominant activity of speech making. So 18.
So predominant activity, the proposed regulation talks about business, trade, or profession. It's all three. The definition of predominant activity applies to all three.
Well, I was talking about regulation 18932.1. But the reality is here is what I want to make clear for the public is if we adopt this regulation, the analysis is not going to change just because we're removing this presumption.
Correct.
So if this case was to go to enforcement, currently, someone would not be able to rebut that presumption.
Correct.
Okay. Okay. Go ahead. All right.
This has been a very spirited discussion, and I, respect and appreciate the advice from Council Bainbridge and also from Senior Counsel Harrison. While I didn't stay up all night, I did look at the advice letters. And if I were a public official or a staff member in any one of the 400-plus cities, those advice letters would have an impact on my opinion. So I'm inclined to support this proposed adoption of the regulation. I think you did an excellent job in terms of narrowing the exceptions and laying out a timeline that is feasible. So my inclination would be, to support it just based on the merits and in terms of whether we have the regulatory authority to adopt a regulation instead of punting and saying only the legislature could change this. That argument can be made on a lot of the regulations that we've discussed since I've been on the commission, because there have been a couple of times when I've questioned, well, does this require that the legislature adopt a law to make this change? And, I'm open to both sides, but I would support this proposed change. So thank you.
And I would just make a comment on the advice letters. My comment is that advice letters are specific to the person that is receiving the advice. They don't go beyond that person. They're not precedent. They can provide guidance, but the facts are often so specific that it can be very difficult to apply an advice letter to your situation. Like I said, you have to understand, are you asking as a candidate or an elected official, or are you asking as a designated employee? Do you have a business and you're asking generally, or are you asking about a specific speech? So you need to be careful. They do provide guidance, but they're not precedent, and we are here to provide advice to the specific individual, and that advice does come with a certain degree of protection for the person that receives that advice and follows that advice, so long as we have a full set of the facts.
Great points. Well, with all that discussion, does anybody have any additional comment? Well, I think we can move on from this now. I'm going to move for approval of the regulation. Do I have a second?
Second.
Excellent, Ms. Linger. Oh, public comment. Sorry, my apologies. Let's continue with public comment. Hearing and seeing none.
Oh, hi, can
Do
you
you have
hear me?
any?
Sorry.
I can now. Good morning. Good afternoon.
Okay, sorry, I didn't know how to unmute. This is my first comment on the new phone, but this is Casey Jenkins on behalf of the California Political Attorneys Association. I don't have anything substantive to add other than that we do stand by the points in our letter and the points addressed by Mr. Winnick in his comment. Thank you.
Well, thank you, Ms. Jenkins. I appreciate that. Any other public comment, Ms. Linger? Okay, then I will go ahead and make a motion to approve the regulation.
Second.
Excellent. Ms. Linger?
Commissioner Baker,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
The motion passes.
Thank you, Ms. Harrison.
Thank you.
Now let's move on to, once I turn my mic, let's move on to item number 7. That's going to be adoption of new regulation 18450.10, an amendment to regulation 18450.9, website advertisement disclosure requirements. And today we're going to be joined by Commission Counsel Caitlin Bieda-Orrick. Good morning.
Good morning, Chair and Commissioners. Caitlin Bieda-Orrick, Legal Division Counsel, presenting 2 regulatory changes for Commission adoption today. First is the adoption of new Regulation 18450.10, which will clarify the meaning of new Section 84513 added by SB 678. New Section 84513 requires a disclosure on advertisements posted on a website, web application, or digital application by third parties who are paid by a committee to post the content. Based on the legislative intent, Regulation 18450.10 will clarify that this disclosure requirement applies to advertisements posted on the internet by third-party influencers who post content where it appears the content is the speaker's thoughts, opinion, or message, rather than that of the candidate or committee, and the content is posted on a page or account other than the candidate or committee's own page or account. Second, staff proposes removing subdivision B from Regulation 18450.9 as it is no longer necessary due to SB 678 adding the disclosure requirement in new Section 84513. I do have an example here to show how the disclosure would appear under existing Regulation 18450.9B and now under new Section 84513. This first example shows the disclosure requirement for advertisements posted by third-party influencers under current subdivision B of Regulation 18450.9 and prior to the passage of SB 678. As you can see, the only requirement for these kinds of advertisements was to have a tag or a link back to the committee's page that paid for the advertisement. However, with the passage of SB 678, adding Section 84513, the disclosure must now be legible to the average viewer and state something along the lines of the author was paid by committee name and committee ID or identification number in connection with this posting. And so, and then in response to commissioners' concerns at the April Commission meeting regarding the placement of the advertisement disclosure potentially being placed at the bottom of a caption of a post, staff does not recommend specifying this language in the regulation since the legislature chose not to include the specific location into this draft. And also other electronic media advertisement disclosure requirements which contain more specific guidelines on the location of the disclosure do not apply to advertisements that fall under this new section 84513. As a result, if the commission would like to pursue a requirement for the placement of the disclosure, staff would recommend that be done by statute as opposed to a regulatory change. I am happy to take any questions or comments at this time.
Excellent. Well, thank you for these slides and your presentation. I'll thank you on behalf of Commissioner Wood, who presented that question and comment related to disclosure. I'm sure she's going to appreciate your analysis and feedback on that. I don't specifically have any questions or comments. Any questions or comments from commissioners? Doesn't look like we have any. Do we have any public comment? Yes, we do. Go ahead, public comment.
Hi, this is Casey Jenkins again on behalf of, excuse me, I'm losing my voice, but on behalf of the California Political Attorneys Association, I just wanted to speak really quickly and express our support for these changes and these amendments. They are consistent. We agree that they're consistent with SB 678, and we appreciate staff's and the commission's work on these. So thank you very much.
Excellent. Well, thank you for your input, I should say. Thank you. Any other comment? Perfect. Okay. I'm going to move to approve item 7.
Second?
Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
The motion passes.
All right, thank you very much.
Thank you. And now we're humming. Okay. Item number 8, 2023-2024 fiscal year third quarter expenditure report. Presenting to us today on that is, it says here, Acting Chief Administration, but I'm going to congratulate her and highlight the fact that she is now the Acting Chief Administration. We're lucky to have her, Dr. Ju Wang.
Good afternoon, Chair Silver and the commissioners, and thanks for the kind words, and thanks for the opportunity excited to take on the more responsibility. So today I'm gonna submit the report as it is, and I'm happy to answer all the questions you have.
Excellent, thank you. Commissioners, any questions or comments on this item? I don't have any public comment. Doesn't look like we have any, not hearing or seeing any public comment. Question for General Counsel, do we have to vote on this? I don't believe so. Just want to make sure we're following the rules of order.
I believe it's just an informational item.
Excellent, perfect. Okay, then we can move on to item number 9, and that's going to be our legislative update with Senior FPPC Legislative Counsel, Ms. Lindsay Nakano. Good afternoon, Ms. Nakano. We've been spending a lot of time together recently.
Yes, it's been busy in the legislature. Good afternoon, Mr. Chair, Commissioners. Nice to see you all. All right, there are 20 active FPPC-related bills, including one new bill that was just amended yesterday. I'll go over that today. All of the bills are now going through the Policy Committee process in the Second House. Some have been heard in the elections committees, and those that have been heard have all passed so far. The remaining will be heard in the next few weeks in those committees. I'll start with AB 1170 by Assemblymember Valencia. This bill requires certain officials to file their Form 700s with the Commission using the Commission's electronic filing system. That bill did pass unanimously in the Senate Elections Committee last week. It was also amended. The amendments make technical changes and require the filer's personal residential address to be redacted from the online copy of the Form 700 posted on the website. We're continuing to work with interested parties on the bill. We expect forthcoming amendments that add some clarifications and detail regarding what may be redacted from the online copies of the statements and when personal residential addresses may be excluded or redacted. AB 2001 by Assemblymember Gallagher, making minor changes to the Act, was heard in the Senate Elections Committee this week. The bill also passed unanimously 7-0. Moving on to SB 1027 by Senator Menjivar. This bill requires redaction of bank account information on statements of organization. That bill was heard in the Assembly Elections Committee yesterday and passed unanimously 8-0.
Right, on to SB 1404 by Senator Glazer relating to lobbying audits and the new lobbyist fee. After additional analysis from the audit division, we discovered that our initial workload projections were overly ambitious. Consequently, we are reanalyzing our fiscal on the bill as well as developing proposed amendments to reduce the workload to a size and volume that can be effectively completed using the revenue generated by the new lobbying fee. We're still in discussions with the author's office on the amendments, but generally we are proposing to require that the commission conduct a flat 65 audits of lobbying firms and lobbyist employers each 2-year audit period. This number is based on what we calculate the audit division can realistically and consistently complete given the number of positions that can be funded by the revenue generated by the new lobbyist fee. And I'll pause here for any questions or discussion before we move on to other
Thank you,
commission
Ms.
bills.
Nakano. And I am going to disclose ex parte communication. I met with Senator Glazer yesterday, and we discussed this bill, as well as the 4 bills currently relating to 84308, including his own. As far as 1404, sounds to me, I don't want to speak for him, but it sounds like he's open to these amendments, and he's not going to let, necessarily the perfect be the enemy of the good, or I'd say extremely important in this case, right? We want to make sure that these lobbying audits are getting done, and this is a obvious way that we can ensure that. One thing that he suggested that I think is an excellent idea is that we somehow, whether that's through regulation or through statutory language, require that 25% of the top, as he put it, top 100 lobbying entities be included in this required mandated lobbying audit program, right? And I know there's various different ways we can go about that. I think he suggested we look at the expenditures made by lobbying entities, I should say lobbyist employers, I believe, and then revenue received by lobbying firms, including contract lobbyists who qualify as lobbying firms themselves. So I thought I'd share that feedback with the rest of the commission so we could all be on the same page. And I'd love to hear if any other commissioners have thoughts on that. I believe he shared that with you as well, Ms. Nakano. So I'd welcome your thoughts as well as General Counsel Bainbridge and Executive Director West to the extent it's appropriate.
I have a few questions, but I know Commissioner Baker's been very involved in this issue. And I know obviously Council Nakano. So I'll wait until they comment before I ask some questions that might be answered when they respond.
Commissioner Baker?
I am more eager to hear. Thank you, Commissioner Wilson. I think you'll have some great questions that I will learn from. So I defer to you.
Well, I have just kind of a technical question. Do we have any idea, ballpark figure, what this, the mandatory lobbying audits, in terms of the fee, how much that would generate?
Charging all lobbyists, I think we're looking at about, and this is off the top of my head, but I think it's about 1.2 million.
Okay. And then kind of a related question, if you have a large lobbying firm versus more of a boutique firm with maybe 1 or 2, employees, how, what would be the potential impact? Because my concern would be if you have a small lobbying firm that it's not such a regressive fee that it would have, a substantial impact on their business.
It is per lobbyist, so I guess to the extent that they're a smaller firm, their total fees would be less.
And that's what it looked like in the bill, but I just wanted to clarify that for the public. Okay, thank you.
Any other commissioners have comments or questions? Commissioner Baker?
Thank you. I appreciate that conversations are still happening. And for my feedback is I'm open to good constructive ideas. Sounds like what we're putting forward or put on the table for discussion includes at least more audits than less, than zero will be happening even if we have a cap. I'm not thrilled about having a cap because I feel like the audits need to be done. And we find out so many things, as we often see with the mainline STIPs that come before us, significant only through the audits and the of so little we know about what's happening with lobbying activity because they just haven't been happening. So having something happen is better than nothing. But I do have concerns about that we're going to cap it so that it stays within our budget. Totally makes sense. And that's better than doing nothing. I'd rather that we have all the authority and we may get those audits done and almost live to fight the day where we get the funding for it. But that's not a directive. I'm sharing with my colleagues my feedback. As Commissioner Wilson says, I've been pretty passionate about this. Happy that there's something out there that could be happening instead of nothing, but let's keep pushing for the most. How's that for big comments on this issue?
I do have a clarification that I hope will put you at ease a bit. 65 is not the cap, but would be the minimum. So to the extent that the audit division has the capacity to do more, they would, but this would be what we're aiming for, the minimum.
Thank you for that clarification. So that helps. It made me feel very uncomfortable that we might be limiting how much we do. Okay.
And I want to thank Commissioner Baker again for making this such a priority. It's astounding to me how few people know about, this deficiency in terms of conducting these audits. I can tell you I certainly was not aware of it before I came over here to the FPPC. So I really appreciate you being such an evangelist for this incredibly important ethical, issue, honestly. So with that, one other thing I wanted to point out that goes to Commissioner Baker's point, and I'm going to attribute this fairly to Senator Glazer. If we see this sort of, not likelihood, I'm trying to think of a better word, if we see the same level of violations in these 65 or more that we're able to do, proportionate to the discretionary audit we did, right, where we did 5 audits, 4 of them found material violations, that is going to certainly give us the type of ammunition that we're going to need and evidence to go back to the legislature and say, we're finding all of this illegal activity. We need more funding in order to conduct more lobbying audits, and we want that to be enshrined in statute so we can guarantee that funding as well. So that eases my concern. I still have a major concern about us not, meeting the threshold that's currently in law, but there is that. So I'm going to ask for public comment if we have any public comment on this one. And one other item, I spoke to representatives of IGA, which is the Institute for Governmental Advocates, I believe. And they were concerned that, the way that we had approached this, I could give the impression that there's a presumption that lobbyists are violating the law. And I told them the way that I view it is completely different. I feel like this is an excellent tool for lobbying entities to show the media, to show the public that they're absolutely acting within the law, right? This is one of the few ways that a lobbying entity can go ahead and say, we're audited within the law. Here's the report. We spent thousands of dollars, if not tens of thousands of dollars probably, ensuring compliance with these rules. And here's evidence that we were acting within the rules. So I actually think it's an excellent tool that can be used by the lobbying community in various different venues. So we don't have any public comment, it appears, so we can move on to the next bill.
Thank you. All right, the next bill is AB 2041 by Assemblymember Bonta. This relates to the use of campaign funds for security expenses. The bill was heard in the Senate Elections Committee this week, passed unanimously 7-0. The bill was amended per committee suggestion to make some technical changes to clarify that funds for personal security includes both funds for personal security services as well as tangible items. Moving on to SB 948 by Senators Limon and Zbur, relating to the treatment of general election contributions. That bill passed in the Assembly Elections Committee 8-0 with amendments from the author. The amendments will make 2 changes. First, the amendments will significantly expand the ability of candidates to transfer funds to future elections by allowing candidates to carry over funds raised for one election to pay campaign expenditures incurred in connection with any subsequent election for the same office. Under existing regulation, the carryover of campaign funds in this circumstance is limited to the next election, not any future election for the same office. The second change relates to the situation where a candidate wins the election outright in the primary, but has already raised general election funds, and this will sound familiar as you've heard the regulation project on this one. The amendments would allow those general election funds to be transferred to a committee for any subsequent election for any office. This was previously limited to an election to the same office. The legal division has expressed some concerns with these changes. They are concerned that these amendments would undermine the contribution limit system established by Prop 34 and the principle that contributions are held in trust. These changes could also make it easier for incumbents to collect large amounts of money, war chests, to raise significant funds for future elections. Any questions or comments on this one before I move on?
I don't think so.
All right, moving on to SB 1170 by Senator Menjivar relating to the use of campaign funds for mental health expenses. The bill passed in the Assembly Elections Committee 6-0, with Assembly members Weber and Asali not voting. The bill was also amended last week to make several changes. The bill makes changes relating to who is qualified to use funds for these purposes, the conditions under which they're able to use funds, the time period that they can use these funds, reporting requirements. The changes add definitions and add record-keeping requirements, and I'll go over some more detail about those. Regarding to who the bill applies to, with the amendments, the bill applies to all candidates, not just non-incumbents. The bill puts two conditions on use of funds. Candidates can use campaign funds if, first, the candidate does not have health insurance or their insurance doesn't cover the full cost of the services, and two, the candidate has experienced harassment, prejudice, or a threat or criminal act, which resulted in the need for services. The amendments make changes to the time period during which candidates can use these funds. Funds may be used starting the date the candidate committee is established to the date that the Secretary of State certifies the election results, or for a successful candidate, the date that the candidate was sworn into office. On reporting, the campaign statement must disclose which category, harassment, prejudice, or a threat or criminal act, the candidate experienced. They are not required to provide further detail on what experience or on that experience on the campaign statement, and they do not have to report the activity to law enforcement and the activity is not required to have given rise to civil or criminal proceedings. The bill adds definitions for threat or other criminal act, harassment, and prejudice. And for record-keeping, candidates must maintain records relating to the mental health care services they receive, including the name, license number, and license type of the mental health care service provider, and invoices for services paid for or reimbursed by campaign funds. Pause here for any questions or comment.
Thank you. I believe we have public comment, but before that, any questions from or comments from commissioners? Okay. Go ahead with public comment. Ms. Roy, thank you for joining us. I got to say, I have just a tremendous respect for your patience sitting through that whole
You guys must be so sick of me at this point.
Excited to see you.
Thank you. Marissa Roy, President of California Women's List. I will keep my comments short. Mostly, I would like to respond to any of your questions. Just that, as you heard last month, we've made the amendments. Thank you so much to Council Nakano for the technical assistance that incorporated the comments you had, Commissioner Ortiz, about balancing accountability and reporting with the category solution. The suggestions you had about timeline and taking out the incumbency requirement, those were all hugely helpful. And what I want to emphasize is that yesterday's committee hearing, we passed out with bipartisan support, which was really exciting. And also Chair Pellerin and Chair Blakespear and both of the Senate and Assembly election committees are now co-authors of this bill, showing the broad amount of support for this bill and this measure. I'm happy to take any questions and just hope that we can get a position of support from the FPBC as well, or keep working on technical assistance.
Well, thank you. We really appreciate you coming consistently and giving us that update. Any questions or comments or motions? And as far as motions goes, I think, after our lengthy discussion last meeting, we're looking to come up with a consensus. I don't think it'd be appropriate to make a motion without Commissioner Wood here on this specific bill. But once we have a whole group together, it's something we can certainly consider.
Okay, sounds good. I will see you in July.
Okay. Well, we're not going to have a meeting in July. Our executive director was just going to tell you that. But we will have a meeting in August, so we'll see you then. Hopefully you get some rest after they go on summer recess.
A long way to come July.
Yeah. Okay, go ahead, Ms. Nakano.
Thank you. All right, I'll move on to the next bill, SB 1476, by Senator Blakespear, relating to the State Bar of California. The bill passed in the Assembly Elections Committee, also unanimously, 8-0. It was amended last week to better effectuate the intent of the bill and the State Bar. The amendments clarify that designated employees of the State Bar and members of the Board of Trustees of the State Bar are subject to the Act's general conflict of interest provisions and must submit Form 700s consistent with their respective conflict of interest codes. I'll move on now to the three bills that amend Section 84308. That's AB 2911 by Assemblymember McKinnon, SB 1181 by Senator Glazer, and SB 1243 by Senator Dodd. Commission staff have recommendations for these bills, and we'll be working in conjunction with other stakeholders and legislators to try to come to some consensus about the best path forward. Staff recommend codifying the definition of pending that's in regulation. SB 1243 by Senator Dodd partially codifies the definition of pending, such that a matter is pending only if it has been placed on an agenda. The current definition in regulation also provides that a matter is pending if the decision is before the officer for their consideration, or the officer knew or had reason to know about the proceeding, and it was reasonably foreseeable that the decision would come before the officer. Commission staff are open to potentially modifying the definition to eliminate the "or had reason to know about the proceeding" element. This means that for this portion of the definition, a matter would be considered pending if the officer actually knew about the proceeding, not merely had reason to know. Staff recommends keeping the 12-month period of the contribution limit that's in current law. SB 1243 would shorten that to 9 months. Staff recommend raising the contribution limit potentially to $500, though other amounts are in consideration. Staff recommend reversing the two changes in SB 1243 relating to agents. The bill provides that the contributions of agents shall not be aggregated with those of parties or participants, and also provides that agents are prohibited from making contributions while the proceeding is pending and for 9 months after the final decision. Staff have also heard from the regulated community that compliance is very challenging with regard to participants for many reasons, including that officers may not know the identity of participants before the hearing or even during the hearing. To address this, staff recommends that the definition of participant be revised such that a person is a participant only if the officer knows that the person has a financial interest in the proceeding. Currently, a person is considered a participant regardless of the officer's knowledge. Staff have also spoken with city attorneys about the unique issues that they face and the many contracts that they provide advice on in the context of their job, and would recommend consideration of a limited exception for elected city attorneys. There are 11 in the state. I'll pause here for any questions or comments.
It's a very helpful breakdown. I appreciate that. So again, I spoke with Senator Glazer about these three bills as well as his specific bill. And it sounded to me like he was looking for feedback from the commission, right? And I believe we've provided that feedback, highlighting what areas that we think would be helpful to either have in his bill through an amendment, or for Senator Dodd or Assemblymember McKinnon to integrate into their bills as well. But, we have other commissioners here. I want to hear what they think about these three bills, what they think about, the issues you've identified, or I should say the items that we feel are important, that we want to be in one of these bills that, that we can support. Because this is a really important issue, right? This is a situation where you have the appearance of a quid pro quo or actual quid pro quos. We want to be erring on the side of caution there, right? We want to err on the side of prohibiting even the appearance of a quid pro quo. So with that, any comments, questions from commissioners? Commissioner Baker, go ahead.
Since they're so strongly encouraged, I'll just add, I think the feedback that we have provided is helpful. It's on improvements. I reiterate, I guess I don't know if I said this pointedly, I have strong concerns about the Dodd bill. I wouldn't say it guts it, but it's very, I think it goes way farther than is necessary to accomplish all the goals that I think the different authors have and interested parties. On the contribution limit amount, I would even be comfortable if it's $1,000. I don't know if that's a compromise with Assembly Member McKinnon and Senator Glazer. I know we've proposed 500. I'm not looking to have us negotiate against ourselves in the middle of this meeting, but this is just feedback to provide. I think our team's done a good job of saying, here's what I think we're comfortable with. That's one area where we may have a little give, at least this commissioner, but more expansive removal of application of the original bill is farther than I think is appropriate to go at this point. And that's one commissioner's feedback for what it's worth.
I appreciate that. And those are great points. One thing that'd be helpful, I think would be helpful for us to know, and I wouldn't expect for us to have an answer to this, but if the Dodd bill went through and it included the removal of agent aggregation, right, and several other provisions that we've highlighted here, would that potentially open it up to a lawsuit for undermining and not furthering the purposes of the act? Is that something we've done before? And like I said, this is kind of out of left field, but it's something that I want to make sure all the authors are considering as they're going forward. Because if they, have all these items in the air, they potentially are opening themselves up to having this new approach struck down. Because I think there are arguments, at least, that it wouldn't further the purposes of the act. So is there anything generally you or Mr. Bainbridge can share on that point?
I don't think I'd want to weigh in on that yet. I'd like to confer more with the legal division. But if Mr. Bainbridge has any comments now, otherwise we can
And honestly, I
respond.
think that's a good approach because this is, a pretty significant issue and something that would take a lot of consideration. So it's just something I wanted to make sure was on everybody's radar, all the parties involved.
I'll consult with the legal division and we can report back in August.
Excellent. I appreciate that, Ms. Nakano. So would you mind running through one more time, just so everybody's on the same page, just in case some legislative offices are watching what we're targeting here?
Certainly. Okay, I'll do a little bit of an abridged version, and if anyone's listening and would like more detail, please get in touch.
It's a great idea as well.
We are suggesting to codify the definition of pending that's in regulation, potentially with some adjustments. We would like to keep the 12-month period that is in existing law for the contribution limit. We recommend raising the contribution limit potentially to $500 or some other amount. Commissioner Baker has expressed also openness to raising it up to $1,000. We recommend reversing the two changes in SB 1243 relating to agents. Those relate to aggregation as well as the contribution prohibition for agents. We are suggesting revising the definition of participant and potentially exempting elected city attorneys from the section.
Okay, that's helpful. And I'd be remiss if I didn't mention one other thing that Senator Glazer brought up. He was interested in the potential of if we're going to raise this up to 500, because he is very opposed, right? That's a very personal belief of his, that anything above 250, even 250, he believes could be corrupted. So,
Mr. Chair, can you put your microphone on? I'm sorry to interrupt.
No, thank you. Thank you, Commissioner Baker. I appreciate it. So what I was saying is that another idea that was floated by Senator Glazer was the potential of, if we raise this up to 500, also changing the gift limit, the annual gift limit, to 500, so that it is consistent with income and the gift limit, right? Everything would be at 500. There's various reasons for that. One of the reasons that he cited was that it would undermine an argument that we're regulating speech stricter than we are regulating the receipt of gifts. So just another thing for us to consider. That's something he floated. I know we're pretty far along in the process, so not sure if that's something that is possible at this point, but it's certainly an interesting policy idea, in my opinion. So with that, public comment on that item? Well, Commissioner Wilson?
Yeah, quick technical question for Councilman Nakano. Did this issue of the threshold come up at the hearing? 250 versus 500 or, a different number?
I recall with Assemblymember McKinner's bill, the threshold in her bill is 1,500. There were some concerns from, I believe, Common Cause and California Clean Money Campaign about how high that contribution limit was, and they expressed that they would continue to work with the author's office on that amount. The difference between 250 and 500, I don't recall that there were any specific conversations on that. But is there a particular point that you're interested in hearing more about?
You answered my question.
Okay.
Thank you.
Okay, great. Any more comments or questions from commissioners? Public comment? Okay, hearing and seeing none, we can go ahead with the rest of the report.
All right, I've got one more, and this is the new bill, AB 2355 by Assembly Members Carrillo and Cervantes. This bill previously amended the Elections Code, and it won't be in your, unfortunately, it won't be in your packet because it was just amended yesterday into the PRA. It previously amended the Elections Code. Generally, the bill requires campaign ads that were created or manipulated with artificial intelligence to include a disclaimer statement. More specifically, the bill requires a committee that creates, originally publishes, or originally distributes a campaign advertisement that was generated or substantially altered using artificial intelligence to include, in a clear and conspicuous manner, a disclaimer that states, "This audio, image, or video has been generated or substantially altered using artificial intelligence." The bill includes additional detail about the form and the appearance of the disclaimer and definitions for artificial intelligence and what it means for an advertisement to be generated or substantially altered using artificial intelligence. The bill provides that it does not apply to ads that were immaterially altered by AI, including a cosmetic adjustment, color edit, cropped image, or resized image. This provision would be enforced by the FPPC, and violations would be subject to injunctive relief or civil or administrative penalties. Commission staff are uncertain at this point how the commission would be able to determine whether an ad was generated or substantially altered with AI. We've brought this question to the attention of the author's office, and we'll continue these conversations in the coming weeks.
Thank you. I think that's an excellent policy idea. I'm very supportive of disclaimers, especially in the AI context. With that said, disclaimers in AI are tricky situations when we're trying to apply the Political Reform Act to them in terms of disclaimers. So I want to make sure we really flush this out, but I'm absolutely, supportive of making sure that the public has information as to what they're seeing is generated or altered using artificial intelligence. So hopefully we can work with Ms. Carrillo's office on addressing any concerns that staff has or anybody in the regulated community. Has Clean Money Campaign or Common Cause chimed in on this at all?
I am not sure, but I can find out.
Excellent. Okay. We have any questions or comments from commissioners? No? Any public comment? Okay. I think that was the last bill, correct?
Yes.
Okay.
Thank you.
Thank you. Now let's move on to item number 10. That's going to be our executive staff reports, and I believe we're going to start with the Enforcement Division. Enforcement Division Chief James Lindsay. Welcome back, Mr. Lindsay.
Thank you, Mr. Chair and Commissioners. James Lindsay, Enforcement Chief. I'm here to present the Executive Staff Report for the Enforcement Division. I do recognize that we're a little bit later in the day than we might have anticipated. As part of the report today, we have scheduled our third installment of the policy directives report, And we have a slideshow for that, similar to what we have done in the past two reports. So much of the material that you'll see is similar in format and somewhat in content. There's some changes, obviously, in some of the results. To the extent that we want to move through it a little bit more quickly, we have a little addition to the slideshow this time, which is two quick summary slides as well, which were designed with the thought for potential public or media use to give an idea of what the policy directives are, what your vision is for the policy directives, and how we are doing implementing that vision that the commission has. So with that, this can be interactive. If we need to move forward with any particular thing, we can do that. I just don't want to take too much time. So the first slide is similar to what we've seen before, and it's quick. It's good to quickly just remind everyone, and especially since we've have a couple of new commissioners since the first report that we did. The policy directives are separated into two sections, Section 1 and Section 2. Section 1 has very specific mandates on case volume. The commission has directed enforcement to reduce our pre-2023 cases, year 2023 cases, by 75% by no later than the end of this year. And secondly, the directive is to the extent practicable and as quickly as possible, reach a carryover case number of 625. And we provide reports on that regularly. These are the two new summary slides that you've never seen before. These are trying to give quick hits on what the goals are of the commission and our success as an enforcement division in implementing those goals. So again, we've got to reduce the pre-2023 cases by 75%, reduce carryover cases to no more than 25 annually, and as part of Section 2, which we'll get into of the directives, is really a goal, stated as a goal, which is a 2-year life cycle. And drum roll, how are we doing? We have reduced pre-2023 cases by 68% so far. And that's not 68% of the goal, that's by 68% instead of the 75. So we're almost to a point that we've achieved that particular directive. We've reduced our open cases, the amount of 65% to what the 625 number would be. That represents the lowest open case total that enforcement has had since sometime in 2016. And as far as the second part of the directives and the goal of a 2-year life cycle, again, I want to reiterate that we closed 66% of our 2023 openings within 2023. That we'll talk about a little bit. It's still, the data is tough to discern in that area just because, you know, the cases that were opened in late 2023 are still very new cases. But we're doing the best that we can to give you as much information as we possibly can on that. Getting a little bit into the depth of what's going on are these the remaining slides. Case closures are represented here on slide 5. As you can see, the gold line is this year to date. You've seen the previous years previously. The gold line is on top of the other years, which means that even though I'm sure the commission has noticed that net case closures have gone down a little bit over the last few months, which we'll talk about a little bit in more detail, that isn't because we're not closing cases. We're still closing cases at a rate, in fact, a rate higher than generally than we ever have before. And so I'm really proud of that and proud of enforcement staff in what we've been able to do and maintain in terms of case closure, reaching well over 100 case closures every month. That was true generally throughout 2023, and it's remained that case in 2024. So appreciate the staff's engagement on this, appreciate the commission's support in reducing cases. It was something that definitely needed to be done, and we're reaping a tremendous amount of benefits from doing that. And if you have any questions, again, on any particular slide, please jump in. Yeah.
Commissioner Wilson?
Thank you, Chief Lindsay. I know that you've commented on this before, but could you put in context how the streamlining program has impacted these numbers, just from a general standpoint, either when you finish or whenever you deem appropriate?
Well, streamline's really important because it's a proper resolution that is it's quicker to come to than some of our other resolutions. It's having a major impact on our ability to close cases appropriately and more efficiently, but also with penalty if that's necessary. It affects our warning letters. PrEP is a big part of that as well. Our PrEP numbers are way up. And so all of those things together are important with case numbers. A lot of the things that the commission has done over the past 5 years has been to increase efficiency, move more things into streamline, make that process a little more user-friendly, and we are implementing that very well as an enforcement division and are getting a number of things through because of that.
Okay, thank you.
You're welcome. All right, slide 6 here is just additional detail on the 75% directive on pre-2023 cases. We started off with 1,415 cases at the end of 2022, as you recall. We're down to 440 of those cases now, which means that we have closed 975 of those cases between the years of 2016 and 2022. We don't have any more cases from 2016 or 2017. We're down to 8 cases from 2018, and we're down to 22 cases from 2029. Those are vastly different than where we were when the policy directives were adopted. And again, very proud of enforcement staff in moving those cases through. A lot of those cases have had some fairly heavy enforcement processes as well, but we've been able to get through a lot of those cases at a very high percentage. We are, as indicated on the slide, if you look at years 2016 through 2020, we are actually at an 80% clip in terms of reduction of those cases. So the composition of cases in terms of how old they are is changing rapidly and in a very positive way. And then just lastly, we'll need 85 cases to close in that range to actually reach the directive that was provided in terms of reducing that level, that particular group of cases to 75%. Again, the second directive is to make all of our attempts to get the overall case numbers down to 625. We started off with 1,415 cases in 2020, at the end of 2022. As of the end of last month, we had 917 active cases. We almost reached the magic goal of 500 net closures. We ended at 498. But that leaves us with 917, as I said. That's a 65% achievement towards that particular directive. The numbers relating to the lowest case total since 2016, it says 885 and 946. 885 is what was reported as the number of active cases at the end of 2015. 946 was the end of 2016. So sometime in 2016, we were at 917, and that's where we are today. And that's a huge win, I think, for the commission and for enforcement staff. Trying to get to 625. There's obviously a lot of things that are going to be happening here. We've got a general election, which we assume is going to create a lot of additional activity. a lot of additional complaints and most likely some additional cases. We don't know exactly how that will play out. We did, as we'll get in maybe briefly into some greater detail, but we did get an uptick in complaints, obviously, for the primary election, based upon where we were at prior to the primary election. We received close to roughly 300 complaints during that cycle. I suspect it will be significantly more for the general election. We'll see where that goes. The short-term goal is that all the gains that we've made on cases, we're going to hopefully maintain that through the general election. I think that's hopefully a reasonable goal. I think it's something that we can do. And then the longer-term goal would be to try to get to 850 cases a year from now. That is not an indication that by any means that we've given up on the 625 number or that we're asking for something different, but I just want to provide, sort of a realistic goal, I think, from where we can be with the general election and where we will be a year from now. We're going to continue to strive to get those numbers to where we are, but there's things that obviously occur that I think on this particular directive, I would ask that the commission, be a little bit patient, I guess, on how quickly we can get to that particular goal.
And that background's helpful. I think it's also worth noting that if we take on lobbying audits, those are going to get completed. And, if we see the same kind of likelihood of violations that we did in the discretionary audits, that's going to include increase your workload as well.
Yeah, absolutely.
Sorry to interrupt you because I know we're in a time crunch.
Oh, no problem at all. And, another issue too, I just want to point out is that as we get farther into certain cases and we lower those case numbers, it does lead to advanced prosecution.
Sorry to interrupt you again, Mr. Lindsay. I believe Commissioner Baker had a comment.
I'm sorry.
Please I'm happy to wait until Mr. Lindsay provides his closing point, because he might be about to address it. Thank you, Mr. Chair. I appreciate the courtesy.
Of course. And one additional thing, I know there's some time limitations for Commissioner Baker. I want to make sure that she's going to be able to make a comment about a item that she wants to have on the next commission agenda. So once we're done with your presentation, would it be possible to go to item 11 so Commissioner Baker be able to mention that and then circle back to 10? Excellent. Perfect. Is that going to work for you, Commissioner Baker?
That is more than an accommodation, so thank you very much. But I will keep letting the train running here and wait till Mr. Lindsay is done with his remark. Thank you so much.
Perfect. Thank you. Go ahead, Mr. Lindsay.
Okay, thank you. We are seeing a significant uptick in more advanced prosecution. For instance, probable cause proceedings and accusations are significantly up. We have had, for instance, 16 probable cause proceedings already this year. We only had 7 all of last year. So what we're seeing is a composition and a changing of things that are beyond case closures. It's leading to scenarios where we are getting deeper into prosecution on a number of cases as well. And that also, those things are timely, take time, and those will have impacts as well in terms of overall case closures. Again, yeah.
Now I'm happy to butt in if that's okay.
Commissioner Baker, go ahead.
It's on that. So I appreciate it's on the prior slide. And first of all, I really am so grateful how clearly you're laying out the numbers of progress that the team has made. That was the goal of the directives. We're getting now into the 2-year timeframe as well as the carryover case. And what I'm hearing is that is kind of just a very direct anticipation that 625 is not going to be met. Is it possible at your next update, which would be in the fall, or I'm not sure if it's in December, that we'll be able to have a more granular, just how far off we're going to be? I understand you're saying the long-term goal and the short-term goal, but it's difficult to make you predict, okay, we're this far off from the carryover cases, this percentage or otherwise, so that we can kind of see it coming a little bit more in detail. And it just may not be possible for you to do at this point, but at least at the next meeting, how far off the carryover cases will be.
Yes, you will absolutely find out where we are with our carryover cases in December, whatever those might be. I can't really predict because we don't know what the general election numbers will be. I'm just trying to give the best estimates that we can based upon the level of closures, net closures that we've been able to achieve this year, and what we're looking at in terms of anticipating how much more we will get in terms of the election from the primary as well. And so we're getting major progress in that area. And again, I may have alluded to this at the last meeting. I wasn't here when the 625 number was, kind of decided upon. And I'm not sure what the data points were to get to that number. I can tell you that there's not a lot of history that I can see that indicates that we've ever really been that low for the most part. There probably was some time in the past, but it will take some time to get to those numbers. We've spent most of the last 8 to 10 years well over 1,000 active cases, in many instances over 1,500 cases. And so, I want to not give the impression that we aren't interested in getting to that point or that we think it's impossible. I'm not saying that at all. I am saying that it is getting incrementally more difficult to find easy closures, if you will. And if we are going to, and I believe that the commission wants us to, give appropriate enforcement to matters, I do think that it's going to take some time, at the very least, to get to 625. It's just that's territory that it's from a historical perspective, it's hard to find that we've ever really been that low.
Thank you.
You're welcome.
Right. So I appreciate some of the historical analysis, but I think for the benefit of the public, it's important to emphasize that, at least based on my experience as a commissioner over the last several years, the staff does extraordinary work. That's reflected in the work done by your predecessors as well. I know that we're taking on audits as an additional responsibility. There's a funding mechanism for that. But when you put it in context, that we have, about 100 employees at the FPPC, and we're going to be assuming a responsibility from the Franchise Tax Board. And if you just go online, they have over 6,000 employees. So it's obviously a staff-driven issue to get to that number. And I think we all know that in this room, but I think for the benefit of the public, they need to understand that the work we do or that the staff does is extraordinary. So thank you.
Thank you. I appreciate that comment very much.
Executive Director West?
Hi, Galena West, Executive Director. I just want to add to that, since I know Mr. Lindsay wasn't here when the directives were implemented. I believe that the purpose of putting the directives in were to give a starting point, but the reporting was then to be considered, and then the commission could revisit the directives and say, okay, so 625, that's not the number, but maybe 700 is the number, or after they have all of the data that has been gathered and presented quarterly, then, and perhaps the audits are added or whatever the changes in workload, that then the commission can say, oh, based on all of the information that we've been given and the recommendations from staff, these are how we want to tweak the directives, or these are how we want to improve upon them, or here's another reporting requirement that we're interested in a category that we're not hearing about now. So it is a kind of a living, breathing document, because it was a starting point that we're now getting all of the information gathered and presented to us quarterly in order for us to make informed decisions in the future.
That's an excellent point. And I hope these slides are available online. I assume that they are, because I think they do an excellent job of showing where we were, and due to your staff and yourself, the commissioners, putting out these directives where we are now.
Yeah, thank you.
Incredible, significant progress.
Thank you. No, this has been I think we've embraced this vision. It was something that has been very good for enforcement, and the implementation of it has had, I think, wide-ranging positive effects for enforcement and getting cases and complaints and everything through more efficiently. And so we will continue to, not a request at all to change the number. We're going to continue working and closing cases appropriately. And time will tell where those numbers can and will go. But we are endeavoring, as we showed on one of the previous slides, I think slide 4 or 5, case closures are higher than they've ever been. But there's impacts there as well, because we have so many efficiencies right now that are going on at the front end. It's also causing a lot of new cases to be opened at a level that we haven't previously had as well. So we're opening cases at a higher rate as well, which has issues in terms of net closures. The 2-year life cycle, again, this is in section 2 within policy and procedure, and these are stated goals versus sort of mandates, because the commission understands and it's acknowledged in the directives that not every case is going to be closed in 2 years. There's a wide variety of factors why a matter won't be closed. There's sometimes you just have to, you don't see eye to eye with people. They think that they want to have a hearing or whatever it might be. There's cooperation issues. Sometimes there's evidentiary issues. But we strive, and the goal is to get complaints and referrals resolved within 2 years, to get cases resolved within 2 years. We are in really good shape on cases, on complaints specifically. The numbers of unresolved complaints are very low compared to where we've been, and very few complaints that are beyond 2024. And in sworn complaints specifically, there's very few outstanding, and there's a very recent. Referrals is a little bit different issue, because we've had a significant number of referrals. We are, though, for the first time since I've been here anyway, we are at least catching up. The referral numbers are going down, but we have a much larger pipeline of referrals than we do of complaints.
And I apologize for interrupting you.
Yeah.
In terms of timing here, I want to make sure that we give the appropriate time to this presentation, right? And we have the ability to ask questions. I'm concerned that we're running up against the lunch hour. I know there's some other time issues for commissioners. Perhaps, assuming other commissioners agree, we could push the latter part of this presentation to our following meeting in August, where we could present questions on this, and we can move on with the executive staff reports. I'm concerned that if we fall below 3 commissioners, then we could have some, technical legal issues. So perhaps that's how we should handle it. Any objection from fellow commissioners? No. Okay, excellent. Commissioner Baker?
No objections. This is our priority when we set apart these commission days, but we sometimes have conflicts or other constraints. I want to thank Mr. Lindsay for preparing this for today, and we are equally interested in it as any day, but knowing that it might allow us to go in much more thorough detail if we do August. So thank you.
Agreed. And again, just want to thank you for preparing these numbers. Want to thank Enforcement Division for making these numbers possible, and looking forward to discussing it in further length in August.
Okay, sounds good. Thank you very much. I appreciate it.
Yeah, of course. And we're going to move on to item number 11, Commissioner comments and proposed future agenda items. I know Commissioner Baker, actually, we're going to circle back to 10 later for public comments, so don't worry, Sasha, we'll be fine. So for item 11, Commissioner comments, proposed future agenda items. Commissioner Baker, I know you have one that you'd like on the August agenda, is that correct?
It is, and I presented so that all of our commissioners know I'm making the request. This is the most transparent way to do it. There was a April 16th, 2024 case closure / advice letter in the matter of John McCann and Melissa McCann and the McCann Legal Defense Fund. We had a news clip about it back in April, and the case closure letter, don't want to put on the agenda revisiting the facts of the case and trying to say we think it should have been resolved a different way. My request is that we can address a couple of issues in the case closure letter. I had talked to Director West when this came out and the matter was closed and the closure letter was made public because there were questions that came up and she answered them, and I think they're the subject of a future meeting, hopefully August. The first one is, there was a statement in the letter that after investigation, the Enforcement Division found insufficient evidence to establish a violation occurred within the statute of limitations, which just, I inquired about, was it statute of limitations or insufficient evidence? And understand that there's been directives and guidance from prior commissions on when we use that language and what that was. And I think that is something that would be helpful, because to me, it's unclear if it's the statute of limitations or if there's insufficient evidence. And since it sounds like language was influenced by prior commissions on what to use in these circumstances, I'd welcome knowing that. It's the first time I've been involved in a commission, understanding the commission had at some point gotten that granular about details. And I thought I made it a little bit unclear, and I think a future agenda will make that more clear. The second is on the statute of limitation and how it's told. In this particular matter, that the statute of limitation, there were transactions that happened in an account that closed later, but the statute of limitations was counted earlier. And I just would like to address how the statute of limitations is told in cases like what was presented here, and if that is something that is commission-driven or legislative and regulatory. And the final is revisiting this particular matter, revisiting the need for legal defense fund audits, because I think this was, and what regulatory-wise we might do in that area. So the closure letter raised those three topics, and I hope that it provides enough direction for the team to come back to us and put that on a future agenda item. And thank you, colleagues, for allowing me to get that detailed.
Thank you, Commissioner. Public comment on that item? Hearing and seeing none. I don't believe we have to move to add an item to the August agenda. So we are going to circle back to item number 10, enforcement staff reports, and we're going to move on with the chief of that division. I should say the chief of the audits and assistance division, Sharada Shah. Good afternoon, Ms. Shah.
Good afternoon. My report for this month is as submitted, but I can answer any questions you may have.
Thank you. Any questions or comments? Any public comment on this report? Seeing and hearing none. Thank you, Ms. Sharada. We're going to move on to the legal division. General Counsel Bainbridge.
I don't have anything to add to what's in the report.
Comments, questions?
I just want to commend, I think, under Mr. Bainbridge's leadership, some of the training that has occurred. It's posted on the website. Could you just give us a little context of some of the training you've been providing? Because I think it's been very beneficial.
Sure. Yeah, we've ramped up the training really in the last year and a half, 2 years. With COVID, we weren't able to give as many trainings. We're facing some budget issues where we can't travel, but we've learned how to do these trainings pretty effectively via webinars. You're right, we've had staff from not just the education division, but I've gone out on a few things. We just had one today or yesterday where Suki Brar, our Assistant General Counsel, met with a coalition of people from government leaders from 4 different continents. So we've been really trying to get out there in lots of different capacities and conduct our trainings.
Okay, thank you.
Excellent. It's a great point. And like I said, I'm just impressed with the work that the legal division is doing, the manuals with trainings, et cetera. I don't know how many times I've taken that Form 700 Bastard Payment training. Every time you put it on, I would be in attendance because it's just so helpful. Okay, any public comment on legal division report? Anybody else want to flatter the legal division? Okay, hearing and seeing none. Why don't we move on to the Administrative and Technology Division? Chief Wang.
Okay, good afternoon, everybody. And I will submit the admin report as it is. I just want to have the one thing add on. I want to give the kudos to our SEI unit staff. They have been working very hard to process all the statement, upload all the paper statement into the system. So as of May 30, which is as of May 24th, all the March 1st group has been, we already received all the March 1st group statement. We will continue working with April 1st group. So hopefully we can reach 100% bar anytime soon. Okay, that's all.
Yeah, and I'd like to highlight that that is ahead of the time period that we've had full compliance in the past.
Yeah,
So I want
that's
to compliment the SEI unit on a job well done.
Yeah, that's correct. Thank you.
Excellent, thank you. Any public comment? Hearing and seeing none, why don't we move on to the executive director update? Ms. Galena West?
Hello, I don't have much. I just wanted to add on to what Mr. Bainbridge was saying. It was a presentation by Suki Brar and Jay Warwanga, our communications director, and they did a PowerPoint, and they it took about a half an hour worth of questions. So there's a lot of interest at these international delegations coming in and asking about how the process in California works. So it's always really interesting, and we don't accept gifts, so we always have to tell them that.
Excellent. Well, thank you for that update. And any public comment on that? Oh, we have a comment on James's report. Go ahead.
Hello?
Hello, go ahead.
Hi, thank you. My name is Andrew Sandoval, and in the staff report, I'm the one that brought the issue regarding the Salinas Valley Leadership Group stipulation or issue. And I'd like to bring some things to the attention of the commission, and with hopes that the commission and the enforcement chief would consider some of the following points. I posed several questions via email, and I also called in, but have yet to receive a response. For example, in count 2, there's $7,292 listed as contributions, and it wasn't clarified whether those were individual contributions or several contributions over the $1,000 amount, which is my understanding would be individual violations. Additionally, there was $14,150 listed in expenditures, but without any specification. Were these political expenditures of over $1,000 or contribution to candidates? I didn't get any responses to those questions either. Count 3 lists $1,748 in contributions, as well as other expenditures, but also without specific details on any amount or total or individual contributions. The staff report did not include the fact that the Salinas Valley Leadership Group had significant previous violations for failure to file 3 24-hour contribution reports. The committee was required to file 24-hour reports within 24 hours, making late contributions totaling $1,000 or more. There were several contributions for $10,000 that were also not filed in 2018. The staff report states no penalty in the last 5 years, which is correct. However, 6 years ago, they had the same type of violations and larger penalties for the same violations. What is not listed in the staff report is whether those contributions or donations were in kind or monetary. In the public records, the Salinas Valley Leadership Group stated that in-kind contributions did not exceed $500, so they are not reportable. But I could not find any information to substantiate that or any attached evidence. I understand the streamlined process, but considering there are unanswered questions, omissions of details on contributions and expenditures, and possibly more violations, along with the previous stipulations being omitted from the report, I believe this merits more attention. I do appreciate speaking to Ms. Evans, who shared that they considered past stipulations, but that information was not listed in the report. I see the report as lacking all the necessary facts. I do appreciate the quick work to make sure items close to the statute of limitations were able to be considered, but in this case, there are other concerns that deserve investigation. I request the commission ask these clarifying questions before accepting the report, or consider asking the staff to reevaluate the facts and present all the information to the commission and to the staff report so the public can know all the details. Thank you very much.
Thank you, and I really appreciate your detailed discussion of that item. I believe that streamline items, however, are essentially informational items. Our hands are tied by regulation as to what we can do at this point. However, I welcome your public comment, and if you'd like to join us at the next committee, I should say commission hearing, and express how you think this could be changed to address the sort of concerns that you raised, that's certainly something that we would welcome. Any other comment, questions from commissioners? Okay, hearing and seeing none. Any other public comment? Okay, so I am going to go ahead and move to adjourn.
Second.
Ms. Linker?
Commissioner Ortiz? Commissioner Wilson?
Aye.
Chair Silver?
Aye.
The motion passes.